Hello, everybody. Jax West from Stephen Avery Project, Justice with Jax, and MAM Gossip. Um, I don't sleep very well. I fall asleep typically around like between 9 and 10 p.m. And then I wake up at like 2 or 3 and are up for hours. And so it is currently 4:23 a.m. and somebody just sent me the state's response. And I posted it on Stephen Avery Project. I shared it on the other pages. And I know most people are going to be asleep right now. So there won't be anybody on this live with me. But I'm up. So going to just start reading. Here we go. I haven't read it yet. I literally got it. I was sitting in my living room, and so I came upstairs, booted up the computer, and here we go. So, good morning. My sexy girlfriend is up already. Oh my god. Or you didn't go to sleep yet. All right. So, I haven't read this yet. Here we go. Response opposing a motion for an evidentiary hearing and post conviction relief under Wisconsin Statute 974.06. The state of Wisconsin, by undersigned counsel, opposes defendant Stephen A. Avery's motion for post conviction relief and request for an evidentiary hearing pursuant to Wisconsin statute blah blah blah. He claims that his new discovered purported witnesses, Thomas Sawinski's testimony, would have allowed him to meet the three-part Denny, and okay, that doesn't matter. The three-part Denny test to introduce third-party perpetrator evidence at trial and allege that Bobby Dassey, Avery's nephew, committed the murder and then planted all the evidence to frame Avery. He also claims that the state committed a violation of Brady versus Maryland by failing to turn over to defense counsel a snippet of audio recorded by the Manitowoc County Sheriff's Office when Sawinski called them on November 6, 2005, which Avery claims would have led defense counsel to Sawinski and allowed them to present this theory of defense instead of the one they chose. He also attempts to relitigate his Brady claim regarding Kevin Romlow's assertion that he told Sergeant Andrew Colborne on November 4 that he saw a car that looked like the victim's parked on the side of the road. Finally, he asks this court to order a new trial in the interests of justice. Oh, here, hold on a second before I go into the next paragraph. Here is. Why aren't you letting me paste it? Hold on. Paste. There we go. There is what I'm reading. Um, okay. The motion is insufficiently pled, unsupported by sufficient facts, and the record conclusively demonstrates that Avery is due no relief on either his newly discovered evidence or his Brady claims. And circuit courts have no authority to order a new trial in the interests of justice unless the request is raised on direct appeal. Accordingly, no evidentiary hearing is necessary, and this court should summarily deny the motion. Background: Teresa Halbach, a 25-year-old professional photographer, disappeared on October 31, 2005. She was last seen walking towards Stephen Avery's trailer after photographing a van on the Avery salvage yard per Avery's request. She was reported missing on November 3. Remember that. So she's been missing since October 31. She lives with a guy on her family's property. Her parents live next door, yet she's not reported for 3 days. Okay, go. And her RAV4 was found on the Avery property November 5. Police searched the Avery property and found burned bone fragments from nearly every bone in the human skeleton in Avery's burn pit, with DNA matching Ms. Halbach's and 2 skull fragments with bullet holes in them, along with rivets from a type of jean she owned. Avery's and the victim's blood in the RAV4. The burned remnants of Ms. Halbach's camera and other items. Ms. Halbach's RAV4 key in Avery's bedroom with Avery's DNA on it. Avery's DNA on the hood latch of the RAV4. And shell casings and bullet fragments in Avery's garage that were fired from the gun in Avery's bedroom, and one of which had Ms. Halbach's DNA on it from the chapstick. A 5-week trial commenced where, quote, the state's theory was that Avery shot Ms. Halbach in the head. Remember, that's theory, not fact. In his garage and threw her into the cargo area of the RAV4, unquote. He then burned the electronics in the camera and cremated Ms. Halbach's remains, transferred some of them to a burn barrel, no sense, and hid the RAV4 until he could crush it in the Avery car crusher. He could have crushed it right then. Avery's theory of defense was that the police were biased against him because of the wrongful conviction lawsuit he had pending against Manitowoc County and the Sheriff's Department, and planted the evidence against him. They did. Quote, the jury found Avery guilty of first-degree intentional homicide and felon in possession of a firearm, unquote. He was sentenced to life without the possibility of extended supervision. Avery appealed and the conviction was affirmed. Avery filed a Wisconsin statute blah blah motion pro se in 2013. The motion was denied and the subsequent appeal was stayed and later dismissed on Avery's motion. Avery then, between 2017 and 2019, filed an additional 6 post-conviction motions alleging myriad claims of error, all of which were denied. Avery appealed and the Court of Appeals affirmed. The Wisconsin Supreme Court denied his petition for review on November 17, 2021. Avery then filed the motion at issue here seeking an evidentiary hearing. He claims that the state committed a Brady violation by failing to provide his defense counsel with the snippet of audio recorded by the Manitowoc County Sheriff's Office on November 6, 2005, when Thomas Sawinski, who used to deliver newspapers to the Avery property, called to report that he needed to speak to someone about the investigation into Halbach's disappearance. He also alleges that Sawinski claims he saw Bobby Dassey and an unidentifiable older male pushing a dark blue RAV4 down the road sometime after Ms. Halbach's disappearance, which Avery alleges is newly discovered evidence warranting a new trial because it would allow him to set forth a third-party perpetrator defense. Finally, he additionally seeks a new trial in the interests of justice. Argument. A circuit court may deny a post-conviction motion without a hearing if the facts alleged do not entitle the movement to relief or, quote, if one or more key factual allegations in the motion are conclusory, unquote. To sufficiently plead a post-conviction motion, the defendant must present, within the 4 corners of the document, the, quote, who, what, where, when, why, and how, unquote, that would entitle him to the relief he seeks. Mere speculation presented as fact is a conclusory allegation insufficient to meet this standard. A sufficiently pleaded motion, however, is not enough to require a hearing. The Wisconsin Supreme Court has recently underscored that, quote, an evidentiary hearing is not mandatory if the record as a whole conclusively demonstrates that the defendant is not entitled to relief, even if the motion alleges sufficient non-conclusory facts, unquote. 1. Avery failed to plead sufficient facts to meet any of the prongs of the Denny test. Quote, when a defendant seeks to present evidence that a third party committed the crime for which the defendant is being tried, the defendant must show a legitimate tendency that the third party committed the crime. In other words, that the third party had motive, opportunity, and a direct connection to the crime. Unquote. Check, check, and check. A defendant's offer of proof on these three prongs is insufficient if it merely establishes a bare possibility that the third party could have been the perpetrator. Rather, quote, it is the defendant's responsibility to show a legitimate is italicized, legitimate tendency that the alleged third party perpetrator committed the crime, unquote. Whether Sawinski's testimony and the other allegations Avery presented actually allow him to meet the prongs of Denny is a threshold question. If it does not, Avery cannot meet his burden on either his newly discovered evidence claim or his Brady claim. And as explained below, Avery has not pled sufficient facts to meet the Denny test, and thus no hearing is necessary on these new claims. Let me pause here. Who's seeking justice? If you're trying to prevent facts from being presented, you're trying to prevent justice. The evidence should at least be heard and seen. And the facts are Manitowoc County covered up evidence. Avery Salvage Yard had how many people living there? But they instantly focused on Stephen. Why? 36 million reasons why. So by just focusing on Stephen and not anybody else who lived at the salvage yard, and to have somebody who says they saw somebody with Teresa Halbach's vehicle before it was found, and saying that this doesn't change the outcome and it's still Stephen and it doesn't matter that this guy, this isn't a guy who watched Making a Murderer and wanted to somehow insert himself into the story. He contacted Manitowoc back when it happened, when there's absolutely nothing in it for him. And you covered it up. Let me continue. A. Motive. Quote, motive refers to a person's reason for doing something, unquote. Avery claims that he has established that Bobby Dassey had a motive to kill the victim because pornography and some gory images were found on the communal computer in the Dassey home. But what Avery presents is, on the whole, a misrepresentation of the facts, and those assertions that are minimally consistent with the record consist of tenuous conjecture only. All right, let me pause right for a second here. But they looked for porn in Stephen's house to try and make a motive for him. So it's very hypocritical to try and say, oh, why would you look at Bobby? Because of porn. But you looked at Stephen because of porn that you didn't find. But you do find it on Bobby's. Yeah. You're being creative by calling it a communal computer now instead of what Sweaty Sweat Ken Kratz called it, Brendan's computer. The computer was in Bobby's bedroom. These searches, these items, everything was done on this communal computer when only Bobby Dassey had access. Let's go back. He falls far short of presenting facts that would establish that Bobby Dassey is the person who accessed the pornography and other images, let alone that anything found on the Dassey computer plausibly establishes that Bobby or anyone else had a motive for Ms. Halbach's murder. What's Stephen's motive? Oh, and there's a footnote on that. Let me go down to the bottom to read the footnote. Avery's contention that, quote, law enforcement considered pornography as evidence of motive in Ms. Halbach's murder, unquote, merely because they collected it and wrote a report about it is false. Law enforcement conducting an examination during a murder investigation gather anything that could conceivably be relevant to the case. Vast portions of what the police collect is later determined to be of no importance. Avery's contention that they seized and reported about this pornography because they believed it was evidence of motive is pure speculation, which he has not supported with any record evidence at all. Okay, so you're now claiming that looking for pornography at Stevens, you're not claiming would have been a motive for him, but what's his motive? All right. The facts of record show that these computer searches are neither relevant to nor probative to establish that anyone, but particularly not that Bobby, had a motive for murder in October 2005. First, Avery has once again failed to supply sufficient facts to prove that Bobby conducted any of these searches. Bobby Dassey was the only one home when these searches were done on the computer. No one else had access to the computer. They were at work, they were at school. Bobby Dassey worked at night. Bobby Dassey was the one at home. Bobby Dassey says that he saw Teresa Halbach and that computer was accessed at those times. As the Court of Appeals noted previously in this case, the mere fact that Bobby could have been home when some of these searches were conducted fails to establish anything about who actually conducted them. And Avery cannot rely on his computer experts or anyone else's speculation on what Bobby's schedule might have been on those days. Bobby worked the third shift or whatever it was. So we know when he worked and when he would be home sleeping. But speculation based on those timestamps from a fraction of the searches is once again all Avery has provided, with no citations to any actual facts of record about Bobby's whereabouts at those times, nor anyone else's who may have had access to the home. And then the footnote on that says, Avery's record citations do not make sense. He cites two and then a whole bunch of numbers, blah, blah, blah. All right, so this is just trying to say, I'm not going to read this whole paragraph, but this is just trying to say that these numbers that he's citing are not the correct numbers for the filings and the documents, whatever. As the Court of Appeals previously observed, the existence of the searches is not a fact that would establish Bobby was even in the house at those times, let alone that he was the person using the computer or accessing these images. These aren't the droids you're looking for. Furthermore, Avery has failed to support his allegations with sufficient factual particularity to establish anything related to Bobby Dassey or even to a crime. There are no timestamps given for the searches Avery points to in Veli's report, and no explanation of how any of them are relevant to an individual's motive for this murder. Most of them are generic and mundane. The mere fact that someone searched for, quote, news, body, journal, and cement, unquote, doesn't show anything similar or related to this crime. When I was trying to fall back asleep, coming up here now and reading this, I'm never going to be able to fall. Now here I'm going to yawn because this gets me so agitated and riled up. Additionally, Avery's own submitted exhibit shows that the bulk of the searches for pornography or gory material that he relies upon for this allegation of motive had no similarity to this crime and either occurred on a weekend when anyone there could have accessed the computer or occurred after 3:45 p.m. on a weekday when Blaine indisputably also had access to it. Nor did Avery account for the fact that Mishicot School District had spring break from March 24, 2005 to March 30, 2005, meaning Blaine and Brendan and anyone they invited over also could have been home on weekdays during that time, and from April 7, 2006 to April 18, 2006, meaning Blaine at least had access during those weekdays. And a footnote says, records of the academic calendars for all Wisconsin school districts for the dates in question can be found at blah, blah, blah. Indeed, of the 128 searches listed, only 28 of them occurred between 7 a.m. and 3:45 p.m. on a weekday. Only 28. Geez, that's nothing. And of those 28 searches, only 3 of them occurred before Ms. Halbach's murder. 2 at 8:14 a.m. on Tuesday, September 13, 2005, and 1 at 7:45 a.m. on Thursday, September 15, 2005. Avery fails to explain how Bobby Dassey's only possibly having searched for pornography a mere 3 times before Ms. Halbach's murder is sufficient to show he was a voracious, violent pornography consumer on October 31, 2005, who was thus motivated to abduct and kill a stranger that day because of it. Well, again, why would Stephen? Oh, but you don't have to show motive. You don't have to prove Stephen had a motive, yet his defense has to prove a motive for the real killer. Wonderful system. Avery once again attempts to rest this theory on Dressler versus McCautry, as if it held that any and all pornography consumption establishes a motive for murder regardless of circumstances. Dressler held no such thing and is not remotely on point, not to mention that as a federal habeas corpus case, it is not binding law in Wisconsin. The facts of the underlying Wisconsin case in Dressler are a vast departure from the facts of this case. There, the male victim was last seen approaching Dressler's house for political campaign activity. He was assaulted and murdered in an extremely specific and particularly brutal way that included binding, mutilation, and dismemberment. And police found myriad weapons and restraints, along with pictures, magazines, and videos depicting similarly murdered and mutilated victims and homosexual pornography in Dressler's home. These items were admitted as other acts evidence of Dressler's intent, motive, and plan to assault and kill the victim in that particular manner. But in that case, 1, there was no dispute that the materials were Dressler's, unlike in this case where anyone could have been responsible for these searches, and Avery has not provided any facts showing otherwise. 2, the materials found in Dressler's home depicted things that very closely mirrored the brutal crime, whereas here the searches Avery is attempting to rely on vary widely from the obscene to the mundane with no relation to how Ms. Halbach's murder occurred. You don't know, nobody knows how her murder occurred. There's no evidence of how the murder occurred. Indeed, Avery fails to point to a single image or search for someone who was shot and the body burned, nor anything that would suggest that these widely varying types of pornography had any similarity whatsoever to Ms. Halbach's murder, and has included such irrelevant and off-point searches as, quote, MySpace, tires, race car accidents, Ford Focus accident, diseased girls, and big woman naked. And 3. In Dressler, there was no dispute that Dressler owned all of the pornographic and violent material before the murder occurred, and they were deemed relevant to show that he was both homosexual and had a fascination with mutilation and dismemberment, and thus a motive, intent, and plan to act out his violent sexual fantasies in this particular manner by the time the victim arrived at Dressler's home. Here, the vast majority of the material on which Avery relies and actually provides some timestamp for has no similarity or even relation to how Ms. Halbach's murder occurred. Again, nobody knows how her murder occurred. And it was not searched for until months after the murder. Avery fails to explain how motive to fulfill a violent, porn-fueled sexual fantasy can be formed or proven by someone not viewing any of this material until months after the murder already occurred. To the extent that Dressler is relevant at all, it actually shows that Avery has not met his pleading burden, because a comparison to it shows why these computer contents would not be admissible as other acts evidence to prove motive if Bobby were the defendant. Other acts evidence is admissible if it meets the familiar three-part test from State v. Sullivan, requiring it to be offered for permissible purposes, relevance, and that the probative value of the evidence is not outweighed by unfair prejudice. The latter two prongs are not met. We are now on page 13 of 38, by the way. Motive is a permissible purpose of introducing other acts evidence. But as explained, none of what Avery has presented is relevant to show motive to commit the specific crime. The Court of Appeals already determined that Avery's contention that these images are similar to the violent murder of Ms. Halbach was false. The pornography and videos of murder and mutilation deemed relevant in Dressler were indisputably Dressler's. They closely mirrored what happened to the victim in that case and were collected by the defendant long before the murder occurred. Nothing about an unidentified person searching a communal computer for various types of pornography and pictures of race car accidents or drowning victims months after Ms. Halbach's murder occurred shows an interest in anything similar to this crime, nor makes it any more or less likely that Bobby Dassey had a motive to shoot and kill Ms. Halbach in October 2005. Nor is there any motive for Stephen. The computer contents are simply not relevant. The searches and images also would be excluded because without some closer tie to the events of October 31, 2005, their prejudicial value would greatly outweigh whatever minimal relevance they might have and influence the jury to convict, because they believed whomever conducted the distasteful searches must be a bad person. Finally, apart from the lack of evidentiary support, Avery's theory that this pornography, accessed months later in 2006, shows that Bobby Dassey had a motive to murder a stranger within minutes of meeting her in October 2005 ignores basic human experience. Despite Avery's inadmissible police procedure expert's opinion, and then the footnote says, Avery failed to show that Greg McCrary has even one relevant credential to give the type of opinion referred to in Avery's motion, and no Wisconsin case has ever permitted a police procedure expert due to the high likelihood of turning the proceedings into a mini trial on the propriety of law enforcement's protocols. Going back up. It is no surprise to find pornography and gore accessed on a communal computer available to at least 4 teenage boys, not to mention anyone else permitted in the Dassey home. But viewing pornography and searching for race car accidents does not create a motivated murderer. Even if Avery could show that Bobby was the one who performed these searches or accessed these images, which again he has provided no facts to support, he provides nothing establishing that viewing these images would give someone a motive for this murder, and certainly nothing establishing that Bobby Dassey specifically had such a motive in October 2005. Avery did not plead sufficient facts to establish Bobby's motive. Before I go on to the next section, let me point out that while Teresa Halbach was a stranger to Bobby Dassey, Bobby knew she was coming and regularly commented to Stephen about Teresa Halbach coming to the property. So the kid was paying attention to when Teresa Halbach was there. So maybe a stranger, but he was a little bit obsessed. B. Opportunity. Quote, the second prong of the legitimate tendency test asks whether the alleged third-party perpetrator, and this is italicized, could have committed the crime in question, unquote. Evaluation of this prong is guided by the defense theory of the third party's involvement in the crime. Sometimes opportunity can be established by simply showing the third party was at the crime scene. When, as here, the theory of how the third party committed the crime requires the person to have carried out a series of complicated and difficult tasks, it is not enough to show the third party's mere presence at the scene and an unaccounted for period of time. In this situation, to meet the opportunity prong, the defendant has to offer evidence that the alleged third-party perpetrator had the skills, contacts, tools, time, and or other means necessary to have committed the crime and staged the scene in the manner the defendant alleges. In other words, quote, evidence that the third party had the realistic ability to engineer such a scenario, unquote. Holding that a third party's possible access to hair and blood samples from the victim was mere conjecture and sufficient to establish opportunity to frame the defendant. Avery's submissions do not meet this threshold. Avery fails to acknowledge that his defense theory has changed drastically from time of trial. Then his contention was that he was framed by law enforcement, who had plenty of time, knowledge, and access to the evidence to plausibly doctor the crime scene. Now he claims his nephew Bobby Dassey framed him and did so in a very short time period. That means that to sufficiently plead his motion, he had to provide more than just a showing that Bobby physically had access to the evidence because he was on the property. He had to show that Bobby had the actual ability to both commit the murder and then complete each step of this framing process, and to do so before November 5. And Avery has not provided facts that would establish at least 4 key components necessary to sufficiently plead that Bobby had the opportunity to kill the victim and plant all the evidence against his uncle: the why, the when, the where, and the how. Assuming for the sake of argument that Avery had pled facts that would establish Bobby's motive to kill in the first place, and as explained above, he has not, Avery has not offered anything that would suggest why, italicized why, Bobby would want to frame Avery, especially given the grave risks and extreme difficulty of doing so. Anyone who murders someone typically wants to escape detection. But that does not explain, and now this is all italicized right here, why Bobby would frame Avery for it. Especially when doing so would ensure that law enforcement would be taking a close and intense look at the entire Avery property and everyone who lived in on it. Really? You want to say they did an intense look at everywhere and everyone other than Stephen and where he lived? I don't think so. He offers no reason why Bobby would want to send him to prison. Oh, I can answer that. Because Bobby hated him. Bobby hated him because Bobby was a piece of crap who was stealing car parts and selling them. He was also dealing drugs. And Stephen, who had some trouble with law enforcement, didn't want to be connected to anything. So Stephen would harp on Barb that her boys suck and she's not doing a good job as a mother when Bobby is selling pot at the salvage yard. And so Stephen was constantly hammering on Barb, and then Barb would tell Bobby. So that would be why he's okay with framing his uncle for it, because he wants to get rid of his uncle because he doesn't like him. That's first. Second, 36 million other reasons why. The family all thought if Stephen went to prison, that $36 million would still happen and now they would get it. Okay. If Bobby Dassey truly wanted to hide the evidence of a crime he committed, there were limitless ways to do so that would not have led law enforcement directly to the Dassey's door. Really? So let me reword that sentence there. If Stephen Avery truly wanted to hide the evidence of a crime he committed, there were limitless ways to do so that would not have led law enforcement directly to the Avery's door. See how that can go both ways there? Lake Michigan, for example, was a mere few miles from the Avery property, and the property was surrounded by vast tracts of undeveloped land. So Stephen could have put it in Lake Michigan. Nor has Avery explained why someone who wanted to frame him would go to such lengths to hide is italicized, the evidence. Surely if Bobby or anyone else wanted to frame Avery, they wouldn't have gone out of their way to make all of the evidence difficult for law enforcement to detect, gather, and connect to Avery. It makes no sense to burn the victim's remains and personal property in an attempt to conceal them, or to drip Avery's blood around the RAV4, but then remove the license plate from and attempt to hide the vehicle by covering it with debris at a point far away from Avery's trailer. Avery has provided no facts explaining why Bobby Dassey's framing him is plausible when he has given no reason whatsoever that would explain why Bobby would do this. Well, then explain why Stephen would leave evidence on his property and why Stephen would then leave home to go to whatchamacallit? Why my Crivets? So you have this evidence, this vehicle that you need to hide. You can't crush it at the time of the alleged crime because family is there, right? That's what the state proposes. So, how about you do it the following weekend when everybody goes to Crivets? Oh, but how do you do how but you go to Crivets too? But Bobby doesn't go to Crivets. Scott's not in Crivets. Stephen goes to Crivets the weekend after he allegedly kills somebody and then leaves the evidence at his home. Makes no sense. Surely, if Bobby or anyone else wanted to frame Avery, they wouldn't have gone out of their way to make all the evidence. Oh, wait, I read that already. Okay. Avery's argument fails on the when and the how, as well as he's provided nothing that could plausibly establish that Bobby had the knowledge, skills, tools, or time to engineer this elaborate ruse. Elaborate. But Stephen is. The mere fact that Bobby was on the Avery property at some time when Avery's hand was bleeding falls far short of facts necessary to establish that Bobby had the opportunity to successfully orchestrate this extremely complicated supposed frame up. Mere presence at the scene of a shooting was oh, this is talking about okay, wait. Third party's mere presence at the scene of a shooting was insufficient to show that the defendant had the contacts and resources necessary to have had the opportunity to orchestrate a hit on the victim. The complete absence of the necessary facts to support several crucial elements of how Bobby could have accomplished staging this scene demonstrate that Avery has failed to plead sufficient facts to show that Bobby had any opportunity to kill the victim and frame Avery in this manner. Avery has offered no facts at all that would establish how is italicized, Bobby Dassey, an 18-year-old high school graduate with no criminal record whatsoever and who was working third shift at a furniture factory. I would like to know what Bobby Dassey's IQ is. One, managed to steal at some unidentified time prior to October 31 the rifle hanging above Avery's bed with which the victim was shot. It's no. Mm-mm. Let me finish reading the paragraph. Um, Hanging above Avery's bed, which the victim was shot, and at some other unidentified time before November 5, managed to replace it with Avery's never noticing. The rifle hanging above Stephen's bed was not Stephen's, nor did Stephen ever use it. That was his landlord, Raleigh Johnson's. Raleigh. Raleigh testified he fired that rifle all over the salvage yard, including at his garage. So, finding casings from that was fired from that rifle in the garage does not mean Stephen used it or that Bobby used it. You got Stephen for being a felon in possession of a firearm. Stephen and Jody lived in Raleigh Johnson's trailer. Almost everything in it belonged to Raleigh. Raleigh. So that gun was hanging over the bed. Stephen paid no attention to it, did nothing with it. Stephen didn't know he wasn't allowed to be in possession of a firearm because Wisconsin would issue him a hunting license. Why do you give him a hunting license if he's not allowed to possess a weapon? But Rowley testified he fired that gun at the garage. Casings found in the garage that came from that gun were fired by Rowley, not from Stephen and not from Bobby. While Bobby is responsible to whatever happened to Teresa Halbach's, he's responsible for her disappearance. Nobody can say either one of them fired that rifle. No proof either one of them used that rifle. All right. 2. Could have abducted and killed the victim and hidden both her body and her car in some unknown area in the minutes between her arrival at the property and Scott Toddock passing Bobby Dassey on the highway around 3 p.m. on October 31, 2005. Nor has Avery provided any facts to establish where the killing could have happened apart from a nondescript, quote, in the RAV4, unquote, or where Bobby could have hidden the RAV4 and the victim's remains in this short period of time. 3. Had the scientific sophistication and knowledge necessary for it to occur to Bobby to collect, transport, and plant Avery's blood from his sink, and as Avery has completely overlooked his non-blood touch DNA on the hood latch of victim's RAV4 and her keys, or how Bobby acquired the skills to do this successfully. I'm just rereading that in my head and processing what they're saying here. Okay. 4. Had a convenient stash of unidentified instruments capable of collecting and transporting liquid blood on hand, or what those might have been. 5. Planted the keys to the RAV4 in Avery's trailer unnoticed and at some unspecified time between November 3 and November 5, yet also either managed to move the RAV4 off the 40-acre property without the keys or drive it away and return on foot from wherever he supposedly took it, and then sneak into Avery's trailer again to hide the keys at some other unidentified time, once again unnoticed. All right, let me dive into that paragraph a little bit. Stephen isn't in his trailer most of the time, okay? So there is a ton of opportunity for Stephen, or for Bobby to go to Stephen's trailer unnoticed. That's first of all. Second of all, drive it without the keys? How do you know that it was driven without the keys? You don't know. And hello, junkyard. I'm sure the kid has learned how to start a car without a key. Just saying there. Then I have done many videos over the years of my time going to Manitowoc and going to all the different crime scenes. The one that Earl and Chuck Avery sicked law enforcement on me is when I went to Cuss Road and then I went to the deer camp. And I showed you on the video just how close Avery Salvage is to the Cuss Road dead end. So it would be very simple and take no time at all to go from the Cuss Road, cutting through, it takes longer to drive around the field than it does to just cut straight through. So, and then also at the turnaround thing that people had seen the car, that's on video too, that I've shown where that is and timed the drive. That also is where Scott and Barb live currently. That also is close enough that you could walk from. But remember, Sawinski saw Bobby pushing the car with somebody else. So somebody else could have been driving and picked Bobby up and taken him anywhere else. So that's how. Sneaking into Steven's trailer, Steven has already said the one door somebody tampered with it. So there's tons of opportunity and evidence that somebody came into Steven's trailer. Six, found and then planted a tiny mangled bullet fragment that Bobby inexplicably knew had the victim's DNA on it underneath items in Avery's garage, or alternatively, how he shot the victim in Avery's garage on October 31. There's no proof that she was shot in the garage. And then at another unidentified time, scrubbed the scene with Avery remaining unaware, this despite Avery indisputably having been working on his Suzuki and other vehicles in and around the garage around this time. There's no evidence she was shot in the garage. Again, finding a casing on the ground does not mean that it was fired there. So there's no proof anything happened in Steven's garage other than this miraculous bullet casing that the garage was filthy, dust everywhere, but not on that bullet casing. I know it's a casing, not a bullet, whatever. So the magic bullet that had paint on it from the garage, why does the casing that allegedly goes through Teresa Halbach have paint on it from the garage? 7. Burn the victim's body in some undisclosed location and then move the remains to Avery's burn pit, again completely undetected, and did it so thoroughly as to include, quote, at least a fragment or more of almost every bone below the neck, unquote, in the entire human skeleton, along with the rivets from her jeans, nor has Avery provided any facts showing where and when this occurred. Where are your facts when and where this occurred? This really bothers me that the state doesn't have to have a motive or evidence or facts to prosecute someone, but you have to show that there is other viable suspects. 8. Convinced his younger brother Brendan to go along with this plan and fabricate a confession implicating himself and Avery, or why Brendan would do so. Who says Brendan did that? Even if one accepts at face value Avery's theory that Bobby was scientifically sophisticated, how and equipped enough for it to occur to him to do all of the blood evidence gathering and planting, Avery provides nothing that would explain how Bobby could have done so in the roughly half an hour window before the blood would have coagulated or dried when Avery was at Menards on November 3. and Avery has not pled even a single fact to establish how or when Bobby could have planted any of the rest of the mountain of forensic evidence against Avery, particularly the victim's remains. It's not proven it's Teresa. The non-blood DNA evidence and the bullet, and also the non-blood DNA evidence. That's what they're calling the sweat DNA. Which I don't know why more people don't talk about this, that I scream from the mountaintops. You had a lab tech state that because they had Stevens Grand Am parked next to Teresa's vehicle, and he was in Stevens' vehicle grabbing things and then went to Teresa's vehicle without changing his gloves. Accidental transfer. Okay. In sum, Avery has provided no facts in his motion that would establish why Bobby would want to frame him. I already told you why Bobby would want to frame him. Or when, where, or how Bobby could have even possibly accomplished any of the necessary tasks to make this theory plausible. It's supposed to be law enforcement's job to find out who committed these crimes. It's not the defense attorney's job to prove a case. It's showing you there's alternative suspects and other possibilities. I personally do not believe Bobby Dassey planted that evidence. I think Manitowoc County Sheriff's Department did it. I am still firmly in belief that they planted the blood, they planted the key, they did the Q-tip blood in the RAV4. I don't think Bobby Dassey did that. He has supplied nothing other than a series of constantly shifting affidavits about this and others' activities during the relevant time frame, and then backfilled it with speculation, with zero factual support, about how a small fraction of the evidence against him, the blood and the car only, could have ended up where it was if someone else was the perpetrator, and pretends the rest of the evidence does not exist. Exhibit 3, which is Sawinski's affidavit. That is flatly insufficient to provide facts that could show that Bobby had the opportunity to engineer this complicated scheme. C. Direct connection. We're now on page 22 of, well, this says 89 down here. Up there it says there's only 30 something, 38. We'll see what happens there. C. Direct connection. Direct connection is assessed by considering, quote, the proffered evidence in conjunction with all other evidence to determine whether, under the totality of the circumstances, the evidence suggests that a third-party perpetrator, in italics, actually committed the crime, unquote, and take the defendant's theory, quote, beyond mere speculation, unquote. Quote, no bright lines can be drawn as to what constitutes a third party's direct connection to a crime, unquote, but it must be more than, quote, a connection between the third party and the crime, unquote. It requires, quote, some direct connection between the third party and the italicized perpetration of the crime, unquote. Sawinski's averments that He purportedly saw Bobby pushing a RAV4 on November 5, several days after Ms. Halbach's murder. Nobody knows when she was murdered, if she was murdered. Do not provide a link between Bobby Dassey and, now emphasize, perpetration of the murder. At the most generous, the exhibits Avery has submitted could establish that Bobby was involved in moving the RAV4 to the location where it was eventually found. And the footnote says this would require a reading of Avery's submissions that ignores their glaring inconsistencies. The information Sawinski initially provided in his emails to counsel does not at all match up with what his affidavits now say about what or who he observed, when he observed them, and who he spoke to at the Manitowoc County Sheriff's Office. And in fact, Sawinski's original information to current defense counsel would have eliminated is italicized, Bobby Dassey as a suspect because Bobby was at work during the time frame Sawinski gave, and Mike Osmundson was nowhere near after having. Wait. Because Bobby was at work during the time frame Sawinski gave, and Mike Osmundson was nowhere near age 60 in 2005. Sawinski's account changed drastically after having his memory refreshed by counsel and her investigators. That is nothing more than a possible, quote, connection between the third party and the crime, unquote. It provides no link at all between Bobby and the perpetration of the actual killing. It also does nothing to establish that Avery was not, italicized, the killer. Even if believed, all Sawinski's evidence would show is that perhaps Bobby was involved in trying to cover up Avery's crime. After all, Avery recruited Brendan to help him try to cover his tracks. The same could be true about Bobby. So now they're trying to say their star witness helped Stephen? Nothing Sawinski avers connects Bobby to the actual killing in any way. And the footnote for that is all of Avery's salacious claims that Mike Osmundson must somehow be involved because he and Bobby spoke frequently, and the two of them did not remember how many years later precisely what date they had a conversation with Avery, or when or what they did when they spent time together, do nothing to support this theory and have no relevance whatsoever to Avery's ability to meet any of the three prongs of Denny. Direct connection requires a showing that, quote, under the totality of the circumstances, the evidence suggests that a third-party perpetrator, italicized, actually committed the crime, unquote. Avery's multiple layers of conjecture piled on top of an allegation that Sawinski maybe saw Bobby pushing a car similar to the victim's at some point do nothing to establish any fact showing that Bobby actually murdered the victim. But then why does Bobby have her car? Don't forget, his brother Blaine saw him driving that car on October 31. In short, Avery's claim that, quote, the Denny requirements are now satisfied, unquote, is wrong. The tendency that Bobby committed this crime, based on what Avery has presented here, has not even entered the ballpark of legitimate. Avery's allegations are conjecture and speculation plugged into unaccounted for periods of Bobby's time. That is insufficient to meet Denny. the dearth of facts in Avery's motion necessary to establish Bobby's motive or opportunity to commit this crime, and then carry out an elaborate planting scheme, along with nothing tying Bobby to perpetration of the actual killing, means Avery has failed to establish a, and this is italicized, legitimate tendency that Bobby was the killer. Avery thus failed to meet his pleading burden on both his newly discovered evidence and his Brady claim. No hearing is necessary. Good morning, Jason. 2. Avery is not entitled to an evidentiary hearing on his newly discovered evidence claim. Avery's newly discovered evidence claim is multi-layered. To be entitled to a hearing, Avery had to plead insufficient facts to establish not only that Sawinski's alleged testimony would have allowed him to meet the Denny test, which, as explained above, they did not do, but also sufficient facts to establish that if he had presented this third-party perpetrator defense at trial, a jury would have had a reasonable doubt about his guilt. He has not done so. Let me again say, if you were a juror on Stephen's case, please reach out to me. I would love to talk to you. It could be off the record. I do not have to say who it was that I spoke to. You can email me at either justicewithjax@gmail.com or official Stephen Avery Project at gmail.com. I would love to hear from a juror that hopefully you've been following the case since and seen all the evidence now that Kathleen Zellner has found. I would like to hear what you have to say. I don't care the state claiming none of this stuff would have done anything to change a jury. I want to hear from the actual jury. If it was presented to you in trial that Bobby Dassey was seen pushing that car on November 5 onto salvage yard property, would it have given you any doubt then? A. Defendants must meet a 5-part test to obtain a new trial based on newly discovered evidence. Quote, to set aside a judgment of conviction based on newly discovered evidence, the evidence must be sufficient to establish that the defendant's conviction resulted in a manifest injustice, unquote. When moving for a new trial based on the allegation of newly discovered evidence, quote, the defendant must prove by clear and convincing evidence that 1. The evidence was discovered after conviction. Check. 2. The defendant was not negligent in seeking the evidence. That's complicated. The state is supposed to turn over everything to you. So there's only so much you can do in doing your due diligence to try to collect evidence. You're assuming the state is going to be on the up and up and give you things that they're legally obligated to do. 3. The evidence is material to an issue in the case. Check. And 4. The evidence is not merely cumulative. Check, check, check. Unquote. Quote, if the defendant is able to make this showing, then, another quote, the circuit court must determine whether a reasonable probability exists that a different result would be reached at trial. End quote. Quote, a court reviewing the newly discovered evidence should consider whether a jury would find that the evidence had a sufficient impact on other evidence presented at trial that a jury would have a reasonable doubt as to the defendant's guilt. Unquote. Quote, while the court must consider the new evidence as well as the evidence presented at trial, the court is not to base its decision solely on the credibility of the newly discovered evidence. Unquote. Instead, the court must ask whether a jury presented with this evidence, regardless of its lack of credibility, would have had a reasonable doubt about the defendant's guilt when considered along with the evidence presented against the defendant at trial. The state disputes that the evidence Avery submitted immaterial for the reasons explained above. Even if Avery could meet the first 4 prongs of the newly discovered evidence test, though he cannot show that this evidence would cause a jury to have a reasonable doubt about his guilt. Hi, Jen. Haven't had my holiday yet. My family is celebrating today, actually. B. Because Avery failed to plead facts that would sufficiently establish 3 prongs of Denny, his allegations that Bobby was the perpetrator would be inadmissible at a new trial. If you're trying to hide and cover evidence, there's something wrong with your case. So why are you going to try to cover up that Bobby was seen pushing Teresa Halbach's vehicle onto the Avery salvage yard? If the newly discovered evidence presented by a defendant would be inadmissible at a new trial, there is no way it could have an impact on the jury's evaluation of the other evidence, and the defendant fails to meet his burden. As Wilson makes clear, quote, the Denny test is a 3-prong test. It never becomes a 1-prong or 2-prong test, unquote. If a defendant fails to make an adequate showing on any of the 3 prongs, the third-party perpetrator evidence is inadmissible. And as the state explained, Avery failed to meet his burden on all 3 prongs of the test. But even demurring on motive, his opportunity evidence is flatly insufficient to establish that Bobby could have committed the crime or staged the crime scene, and his direct connection evidence doesn't establish a connection between Bobby and the actual killing. Accordingly, no jury would ever be presented with what Avery has submitted here, and therefore there is no possibility that it could affect the outcome of a new trial. Jen, yeah, this is just the state's response. We still have to wait for Judge Flowers, but of course we know Judge Flowers is going to be saying no. I mean, and it's always been known that they're going to say no. That this level court is always going to say no. They're going to continue to cover it up, and it's just constant bullshit. It's just that they're also able to drag it out like this for Stephen to try and take it to the next level. You know, just more time an innocent man has to sit in prison. C. Even if this evidence were admitted and this theory of defense were presented, there is no reasonable probability of a different result at a new trial. Even assuming that this was sufficient to meet Denny and Avery had a new trial presenting this defense instead of the police bias defense, there is no possibility that any jury hearing it would have a reasonable doubt about Avery's guilt. Ooh, they're mind readers now. As explained above, there are far too many irreconcilable inconsistencies between Avery's allegations about Bobby Dassey and the actual evidence produced at trial. Particularly damning would be Avery's complete failure to account for his DNA on the hood latch. I've already told you how that sweat DNA got on the hood latch of the RAV4 and Ms. Halbach's remains, again, including a fragment from virtually every bone in the human body being found in his burn pit, and nothing to explain how Bobby could possibly be responsible for the bullet with Ms. Halbach's DNA on it being found in his garage and matched to the gun above his head. Right, Shane? Ugh. Avery's new defense would essentially be asking the jury to ignore the forensic evidence introduced against him. When presented with the common sense explanation that the evidence was located where it was because Avery shot and killed the victim and then attempted to hide the evidence of his crime, versus Avery's attempt to paint Bobby as a porn obsessed, scientifically savvy, and extraordinarily stealthy criminal mastermind who inexplicably wanted to frame his uncle, no one would have a reasonable doubt about Avery's guilt. Quote, courts may permissibly find, as a matter of law, that no reasonable jury could determine that the third party perpetrated the crime in light of overwhelming evidence that he or she did not. Unquote. Here, overwhelming evidence that Bobby did not commit this crime exists in the utter absence of any facts tying him to the actual killing or to even a single piece of the forensic evidence. Avery's theory requires so many speculative leaps, ignoring the actual facts of the case, that reasonable moviegoers would be hard-pressed to sit through it. Really? You're gonna say that when Making a Murderer was an international sensation? I'm gonna guess they would sit through it. Any reasonable juror being asked to search for the truth in a murder trial would reject it without fail. They're brilliant. They know what a jury would think. How do they ever lose a case? 3. Avery has failed to plead sufficient facts to establish a violation of Brady versus Maryland, and the record conclusively proves that he could not do so, so no hearing is necessary. A. Avery failed to provide sufficient facts to establish this audio clip's materiality. Under the Fourth Amendment, quote, suppression of the prosecution of evidence favorable to an accused upon request violates due process where the evidence is material either to guilt or punishment, irrespective of the good faith or bad faith of the prosecution, unquote. The evidence must be, quote, favorable to the accused either because it is exculpatory or impeaching, unquote. It, quote, must have been suppressed by the state either willfully or inadvertently, unquote, and it, quote, must be material, unquote, to the defendant's guilt or punishment. Evidence is material and therefore must be disclosed, quote, only if there is a reasonable probability that, had the evidence been disclosed to the defense, the result of the proceeding would have been different. A reasonable probability is a probability sufficient to undermine confidence in the outcome, unquote. However, quote, showing that the prosecution knew of an item of favorable evidence unknown to the defense does not amount to a Brady violation without more, unquote. And, quote, a defendant's request for Brady material, ... Remember, ... means there's other stuff that was written, but they're omitting that to try and streamline what they're trying to get across. Does not require a prosecutor to wade through all government files in search of potentially exculpatory evidence, unquote. Importantly, for the issue raised here, Brady does not require the prosecution to disclose evidence that is merely potentially exculpatory. Stated differently, the state is not constitutionally required to turn over, quote, the type of information that could form the basis for further investigation by the defense, unquote. Courts' differentiation between potentially useful evidence and exculpatory evidence required to be disclosed under Brady. Avery has again failed to meet his pleading burden because he has not submitted anything that would establish an actual Brady claim, even if true. There are several glaring failures with what Avery has presented. First, Avery's dogged insistence that Bobby Dassey, quote, was the state's primary witness against Mr. Avery at his trial, unquote, remains false no matter how many times he repeats it. Bobby established only that Ms. Halbach arrived at the Avery salvage yard on the day in question and that he saw Ms. Halbach walking toward Avery's trailer shortly before she disappeared. The state's 16 law enforcement witnesses and 12 forensic scientists who explained the enormous amount of forensic evidence pointing directly to Avery as the killer were all far more material than Bobby, and Avery fails to explain how attempting to impeach Bobby with this purported evidence would have turned the tide at trial. Second, Avery's submissions are insufficient to establish any facts related to this claim. Avery has presented nothing more than an unauthenticated piece of paper on which some unidentified person apparently typed their interpretation of what was said in an audio clip at some unidentified time. Absent from what Avery submitted to this court is any copy of this audio clip, let alone any documentation about when it was received by the sheriff's office, who answered, who transcribed this clip, when they did so, when they were using what they were using as a reference, any timestamps, or anything else that would provide some verification that what Avery submitted is actually true and accurate. It is a bare piece of paper with some words typed upon it. This is not evidence. And the footnote says, Avery notably also did not provide any affidavit from Sergeant Senglob or any investigator who spoke to him that would show that Sawinski was actually connected to him when this call was actually made, and does not establish that anything Sawinski says now was actually what he told Senglob at the time. The audio clip establishes nothing substantive, and the record shows that Sawinski was not telling this new story until defense counsel somehow refreshed his memory 17 years later about what he believed he saw and when, with no documentation that would show how this memory refreshment could have been achieved. Accordingly, Avery's failure to submit anything from Senglob means he has additionally failed to submit sufficient facts that would show that law enforcement was actually in possession of Sawinski's purported information in 2005. Oh, yeah, sure. Let's talk to Sergeant Senglob, because of course he's going to say, yeah, I did XYZ, and that he's not going to continue along like Andy Colborn, who receives information and does nothing with it and years later writes a report. We already know multiple instances of Manitowoc Sheriff's Department covering crap up. Assuming that everything Avery submitted is accurate, though, he still hasn't established that this material evidence that was required to be disclosed to the defense. There are literally no details contained in the audio clip that would indicate that Sawinski had materially exculpatory information. Sawinski said nothing other than he had something that he didn't know if it was, quote, good information, unquote, or, quote, bad information, unquote, about, quote, the girl who is missing from Hilbert, unquote. That is everything contained in the audio clip. Nothing in those few sentences could even conceivably be considered materially exculpatory evidence that the prosecution should have been on notice to turn over, and indeed, Avery actually does not attempt to argue that the contents of the phone call are materially exculpatory or impeaching. What he argues is that if the defense had been provided with this snippet of audio, they could have tracked down and interviewed Sawinski. But that does not make this phone call clip Brady material. It makes it an avenue of investigation that could have led anywhere, which is insufficient to establish that it was materially exculpatory. And significantly, absent from Attorney Buting's or Attorney Strang's affidavits, is any allegation that would have pursued Avery's new Denny theory if they had Sawinski's new information. They say only that they could have, quote, pursued the information that Sawinski called the sheriff's department diligently, unquote, and would have, quote, made a specific request for further information about the substance of that call from Sergeant Senglob, unquote. There's no allegation that they would have attempted to present this fanciful theory that Bobby Dassey was somehow responsible for the murder, either at the pretrial Denny hearing or at trial, if they had spoken to Sawinski. And it is easy to see why. No reasonable jury would have believed it. Again, just they know everything the jury would think. The police frame-up theory was a far more believable defense. I still believe that's what happened. And Zellner does not have to prove what actually happened. She just shows you that there are these other things that are more probable. So she's told you about the police framing him, told you about Bobby framing him. Both are more possible and probable than Stephen committing this crime. Sorry. Not sorry. Again, evidence is only material if there's a reasonable probability that it would have made a difference in the outcome of the trial. A defense that would not have been presented would not have made a difference in the outcome of the trial. Therefore, Avery's affidavits are insufficient to establish facts to support a Brady claim. Right, Dave? So all Avery has established and argued is that if he'd been provided this phone call clip, he would have had, quote, information that could form the basis for further investigation by the defense, unquote. That is demonstrably insufficient to state a Brady claim. Really? You think it's no big deal that somebody saw Bobby Dassey and somebody else pushing the car to the salvage yard? That's not important to the case at all and wouldn't have changed anything. That's just crazy to me to think that that's not important. B. Avery's Brady claim regarding Kevin Romlo was previously litigated but also fails on the merits. Avery attempts to relitigate his Brady claim that Kevin Romlo allegedly told law enforcement that saw Ms. Halbach's RAV4 off of the Avery property on November 3, 2005. By his own admission, he already made this argument to this court in his motion for reconsideration in October of 2017 on the grounds that Romlo's information was newly discovered evidence of a Brady violation, and he again relied on it as part of his July 2018 supplemental motion alleging that the contents of the Dassey computer would have allowed him to establish Bobby as a Denny suspect. This court denied the myriad new claims Avery raised in his motion for reconsideration on the grounds that new claims were not an appropriate reason to reconsider an earlier decision. Isn't that just crazy? Quote, a matter once litigated may not be relitigated in a subsequent post-conviction proceeding, no matter how artfully the defendant may rephrase the issue, unquote. I call bullshit. Bullshit, bullshit, bullshit. It's still important. I don't care that the judge said no to it. Don't care. Doesn't change the facts that this guy saw the RAV4 off the property. So you had one guy who saw the RAV4 off the property. You have another guy who saw Bobby Dassey pushing it back onto the property. Those two things are very important. And when you toss the first one of the guy seeing the car somewhere off the property, and now have this guy who saw the car being pushed onto the property, it makes perfect sense that you'll bring back up the first guy. Quote, a matter once litigated may not be re-litigated in a subsequent post-conviction proceeding. Oh, I already read that. Avery already litigated this claim. In 2017, he claimed Romlow's information was newly discovered evidence warranting reconsideration of this court's order 2017 decision pursuant to blah, 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 blah. The fact that this court did not individually address it when denying his motion for reconsideration is immaterial. It was presented to this court previously under one particular legal theory, and this court properly denied it, meaning Avery cannot relitigate it now. Just as, quote, an appellate court is not a performing bear required to dance to each and every tune played on an appeal, unquote, neither is a circuit court required to individually address in detail claims that are improperly before it if it explains why they are improperly raised, which this court did in its prior decision. This court's failure to address it on the merits previously does not permit Avery to continuously re-raise it until this court does so. C. The record conclusively demonstrates that Avery could not establish a Brady violation at a hearing. Even if this claim was not previously litigated, it would fail, because the record conclusively demonstrates that what Romlow says in an affidavit about telling Sergeant Andrew Colborn on November 4 that he saw the victim's RAV4 on a highway cannot possibly be true. Sergeant Colborn ended his shift on November 3, 2005, around 11 p.m. The affidavit Romlow submitted unequivocally states that midday at November 4, quote, while he was in the Senex station, a Manitowoc County Sheriff's Department officer came into the station, unquote, whom he claims he told about seeing the victim's car, and that it wasn't until December 2016 that he, quote, recognized the officer who he talked to at the Senex station, unquote, and that it was Colborn. But Colborn was off of work on November 4, 2005, meaning he would not have been in uniform or driving a squad car that day. Wanna bet? That doesn't mean anything. Even assuming, and it is a big assumption, that Colborn actually went into a Senex station on November 4, Romlow, by his own admission, does not know Colborn personally. Romlow had no idea who Colborn was until he saw him on TV in 2016, and subsequently nothing Romlow states in his affidavit or that is claimed in Avery's motion could possibly have happened. Colborn could not have been identifiable as a Manitowoc County Sheriff's officer while he was off duty and thus out of uniform in a gas station, and there is no way that Romlow saw him come into the gas station, identified him as a sheriff's officer, and told him this. The record thus conclusively demonstrates that the state did not suppress any information about Romlow's tale because there was nothing to suppress. The evidence did not exist. Okay, so I'm not going to pull it out, but the crime scene log of all the different people from Calumet County and Manitowoc County that are in and out of the crime scene. And now remember, Manitowoc was not supposed to be doing anything on this case. Yet Manitowoc is all over it. Why? What's the excuse? Oh, we had to call in everybody from everywhere to help us with this extremely important case. So that's why Colborn and Lank, who, helped put Stephen in prison the first time for something he didn't do, were still part of this one. So, Colborne is off duty. So that means he wouldn't be working on the Avery case at all now, would he? And in doing the things, in whatever he was doing to on this case, no, he wouldn't just continue to wear his uniform and drive his car so nobody thinks twice about anything that he's doing. No. Inconceivable. Every time I hear that word, I think of Princess Bride. And I probably sound similar too since I have a lisp, right? Inconceivable. No. Colborne, absolutely. As soon as he punches out, he is out of uniform. He's not Mr. I'm important. Look at me in my uniform. Nope. Nah. Finally, Avery has once again failed to plead sufficient facts that this information from Romlo could have been material. As explained above, Avery did not plead sufficient facts to satisfy the three prongs of Denny and allege that Bobby was a plausible perpetrator, so the jury would not have heard that theory, which is the only way there would have been any exculpatory context to this information. Assuming that Romlo's information standing alone would have been admissible, there's no reasonable probability of a different result at the trial. Romlo seeing a car similar to the victim's on the side of the road between November 3 and November 5 does nothing whatsoever to exonerate Avery. Avery himself could easily have driven it there. After all, the state had no way of knowing what Avery did with the evidence between October 31 and November 5. Oh, but wait, you said Avery's never left the salvage yard. At best, Romlo's evidence would have allowed the state to fill in its own gaps in how Avery kept the victim's car hidden between her disappearance and the car's discovery on November 5. There is not a reasonable probability the jury would have reached a different outcome if presented with Romlo's testimony. Because, yeah, that makes perfect sense. Perfect sense. Remember, I've told you all, if I ever came across any evidence that showed Stephen was guilty, I would declare it. So here I am now stating, oh, there it is, people. Whoop, there it is. Of course, Stephen took the car off his property and then brought it back and put it there in his own property to be found. Of course he did. That makes perfect sense. Take the evidence away so you can't be tied to it, but then bring it back. You don't bring it back at the same time that you then crush it to get rid of it. You bring it back, you park it in a section of the pit that it doesn't belong. You know, to you and I, it just looks like a bunch of junk cars everywhere. But to the family who ran that, there was a method to the madness of where cars were parked. Cars from this year to this year are here. Cars of blah, blah, blah are here. So you park it in a section that is not where that kind of car belongs. You double park it and have it going a different direction than the rest. And then you put a couple of things on it, just to further make it stand out. There you go. You've convinced me Stephen is guilty. Why didn't I think of that? That the best thing to do is to take the evidence off your property and then bring it back. And then instead of getting rid of it when your entire family is going away for the weekend, so you'd have the place all to yourself, no eyes to watch you crush a car and get rid of bones in your burn pit. Nope, you go with too. You leave and just leave that evidence laying around. You got him.
4. Circuit courts have no authority to grant a new trial. We're now on page 37 of 89, and I've been on for an hour and 40 minutes now. Holy cow. Circuit courts have no authority to grant a new trial in the interest of justice when the request is made in a Wisconsin Statute 974.06 motion. Avery's final request is that this court grant him a new trial in the interest of justice pursuant to Wisconsin statute blah blah blah. There is no need to belabor why Avery fails to meet the requirements for such relief, because the Wisconsin Supreme Court has unequivocally held that circuit courts have no authority to grant new trials in the interest of justice in criminal cases pursuant to Wisconsin statute blah blah blah. Nor can such claims be raised in Wisconsin statute blah blah motion because they are neither jurisdictional nor constitutional. All-time stupidest case. Interest of justice claims can only be considered by the circuit court if they are presented in a defendant's Wisconsin statute blah blah motion on direct appeal. As this is not such a motion, this court lacks the authority to grant Avery any relief of this claim. Conclusion. See, there's conclusion, but it's so this is saying on this we're about done, but then there's like a whole bunch more. We'll see what that is in a second, if it's anything. Conclusion. Avery has not pled sufficient facts to meet the 3 prongs of Denny, and the record conclusively disproves much of what he states, which means his Brady and newly discovered evidence claims could not prevail even if he established the facts he alleges at a hearing. Even if he had met his pleading burden, though, what he submitted did not establish he could meet the newly discovered evidence or Brady tests because he cannot show that there is a reasonable probability of a different result at trial if the jury were presented with Sawinski's or Romlow's evidence. This court should deny Avery's motion without an evidentiary hearing. Dated this 23rd day of November 2022, respectfully submitted by Joshua Call, the Attorney General of Wisconsin, electronically signed by Lisa E.F. Comfer, Assistant Attorney General. All right, so the next page is Thomas Sawinski's Gmail. Thomas Sawinski to Stephen Avery Lawyers. Saturday, December 26, 2020 at 10:42 p.m. Just finished second season. I lived there at the time. I was a motor route driver that was on the property every day to deliver newspapers. A few days before they found the RAV, I was delivery papers at about 1 to 2 a.m. and saw Bobby Dassey and another old man pushing the RAV down the road toward the junkyard. No lights at all. I almost hit them. They were very spooked. As you know, it's a dead-end street. After delivery paper, I had to go right back past them. Dassey stood in the road next to the RAV trying to stop me from getting by. As I approached, my headlights were on them 100%. Other guy hid behind open passenger door that was open from pushing the vehicle. I didn't slow down and drove in the ditch to get by, waving as I said, "Paperboy, gotta go." Dassey had no shirt on, and the other guy had a very scraggly beard and seemed to be in his 60s. I did call police, and they said they would contact me. They never did. After season 1, I emailed an attorney of Stevens and no response. I've decided to reach out one more time as this information seems vital, especially after what I just watched. I live in Denver now, but lived in Manitowoc for over 20 years. So that's Exhibit 1. Exhibit 2, or no, it says Exhibit 4. Is another email from Sawinski. And this one is Thursday, January 7th, 2016, 1:43 p.m. Hello, my name is Thomas Sowinski, and I delivered newspapers to the Avery residents every day for years. I delivered papers at the time of the Hallbach situation. Somewhere between October 31st and November 5th, 2005, not sure which day, I turned down Avery Road to deliver their paper when I almost ran into two people pushing a dark colored small SUV down the road with absolutely no lights on. It was dark and I delivered the papers as soon as possible each day so I could get home in time to get my son ready for school and drop him off. As I passed them, I realized I had stumbled onto something that seemed out of place. I spooked both of them tremendously. I drove down the dead end and put the paper in the tube and turned around to come back down the road. I knew I was in a shady situation, so I approached them with a good amount of speed to get around them fast. As I approached, the guy pushing from the driver's side stopped and tried to stop me in the middle of the road. I went half in the ditch and just waved to calm the men into thinking I was oblivious to what was going on. I didn't I didn't I didn't see who the man was on the passenger side, but the young man, maybe 18 or so, that tried to stop me was not Brendan Dassey. His build was thin and fit, about 5'9" tall. Days later, after seeing the footage on TV of the RAV4 being found on the property, it clicked that it was probably the SUV I had seen that night. I called police and notified them. They didn't seems interested. I'm just reading it with the typos at all and said thanks for the info. Never asked me to fill out a report or even asked for my name or phone number. At the time, I just figured they had enough evidence and we're not concerned with my information. After seeing the documentary on Netflix, I decided that someone other than Manitowoc County officials need to hear this. They were pushing in the direction towards the house from the highway. I feel obligated to share this now, and I know some of the circumstances involving the way Manitowoc handled the case. Next is Court of Appeals decision dated and filed July 28, 2021. State of Wisconsin versus Stephen Avery. Appeal from orders of the Circuit Court for the Manitowoc County. Angela W. Sutkowitz, Judge Flowers affirmed. Per curiam opinions may not be cited in any court of the state as precedent or authority except for the limited purposes specified in Wisconsin statute blah blah. In 2007, following a jury trial, Stephen A. Avery was convicted of first-degree intentional homicide, party to the crime, and possession of a firearm by a felon. We affirmed his conviction on appeal. The issues in this case concern collateral proceedings, whether the circuit court erred in denying Wisconsin statute blah blah motion and two supplemental motions without a hearing, as well as his motions to vacate and for reconsideration of the first of these motions. We hold that Avery's motions are sufficient on their face to entitle him to a hearing, and that the Circuit Court did not erroneously exercise its discretion in denying the motions to vacate for the reconsideration. Accordingly, we affirm. Overview. We previously summarized the facts of this case and our decision on Avery's direct appeal, and we will discuss below those facts relevant to his collateral attack on his conviction. But for context, this case began in early November 2005 with the disappearance of Teresa Hallbach, a 25-year-old professional photographer. Volunteer searchers found Hallbach's RAV4 on the 40-acre site of Avery's Auto Salvage, a salvage yard business where Avery and other family members lived and worked. It was believed that Hallbach had photographed vehicles at this site several days earlier per Avery's request. According to state witness Bobby Dassey, Hallbach was last seen walking towards Avery's trailer. Well, no. Bobby last saw, allegedly. After finding the RAV4, police searched the Avery property and, over the course of the next 4 months, discovered and identified evidence including burned bone fragments in and around a burn pit with DNA matching Halbach's mother, both Avery's and Halbach's blood in the RAV4, the remnants of electronic devices and a camera, the same models as Halbach's, in a burn barrel, Halbach's RAV4 key in Avery's bedroom, her valet key, with Avery's DNA on it, Avery's DNA on the hood latch, sweaty sweat sweat, of the RAV4, deposited, the state later claimed, by Avery's sweaty hands. See, they have sweaty, sweaty, sweat, sweat. And a bullet and bullet fragments in Avery's garage containing Halbach's DNA. The case was tried over a 5-week period in February and March of 2007. The state's theory was that Avery shot Halbach in the head in his garage and threw her in the cargo area of the RAV4. He then burned the electronics and camera, cremated Halbach in a burn pit, transferred the remains to a burn barrel, and hid the RAV4 until he could crush it in the Avery car crusher. But that would happen after he goes out of town. You know, he's going out of town, so he doesn't take the RAV4 to Crivets. He doesn't take the bones or the electronics to Crivets. He just leaves that all there and then leaves. Makes perfect sense. The defense argued that law enforcement was biased against Avery, who is pursuing a wrongful conviction lawsuit against Manitowoc County and the Sheriff's Department. Footnote says Avery was wrongfully convicted of a 1985 sexual assault and was exonerated in 2003 on the basis of DNA evidence linking the crime to another person that Andy Colborn knew about. I have to. Where was I? Where was I? There it is. I had to find where the footnote was. And as a result, planted evidence implicated Avery. The real killer, the defense argued, took advantage of this investigative bias to also plant evidence on the Avery property, once early media publicity made it clear that Avery was a key suspect. The jury found Avery guilty of first-degree intentional homicide and felon in possession of a firearm. Avery received a life sentence without the possibility of extended supervision. In 2009, Avery commenced his direct appeal by filing a motion for post-conviction relief pursuant to Wisconsin statute requesting a new trial. That motion was denied. Avery appealed, and this court affirmed in the aforementioned decision. 6. In 2013, Avery filed a pro se Wisconsin statute motion requesting a new trial. That motion was denied, and Avery appealed. That appeal was stayed and later dismissed on Avery's motion shortly after he initiated the post-conviction proceedings that are the subject of this appeal. In 2017, Avery filed the first of the 6 motions that are subject of this appeal. And there's a footnote that says Avery's appeal is from 2 orders. The Circuit Court's October 3, 2017 order denying his June 2017 post-conviction motion, and the court's November 28, 2017 order denying his motions to vacate and for reconsideration of the June 2017 motion. We address these as motions number 1 through number 6. After filing his appeal, Avery moved to supplement the appellate record and to stay the appeal and remand in 2 separate motions. We retained jurisdiction and directed Avery to raise his claims to the Circuit Court in the form of supplemental post-conviction motions. We address these as motions number 4 and number 5. In April 2021, Avery filed a motion to this court to stay his appeal and remand. We have not yet acted on that motion, so we address and decide it as motion number 6. And then it continues at postscript for the next page saying, all grounds for relief available to a person under this section must be raised in the defendant's original, supplemental, or amended motion. Any ground finally adjudicated or not so raised or knowingly, voluntarily, and intelligently waived in the proceeding that resulted in the conviction or sentence, or in any other proceeding the person has taken to secure relief, may not be the basis for a subsequent motion, unless the court finds a ground for relief asserted which for sufficient reason was not asserted or inadequately raised in the original, supplemental, or amended motion. All right, back to where we started. These motions will be analyzed individually with further discussion of relevant law, but some basic principles apply generally. Wisconsin statute blah blah provides a mechanism for vacating, setting aside, or correcting a sentence once the time for direct appeal is passed on constitutional or jurisdictional grounds of or where, quote, the sentence was in excess of the maximum authorized by law or is otherwise subject to collateral attack, unquote. Section whatever, however, creates a procedural barrier to review in that it requires the defendant to raise all grounds for relief in his or her first post-conviction or appellate motion. Thus, a defendant is normally barred from raising issues in a motion that were or could have, in italicized, or could have been raised on direct appeal or in a previous motion. An exception to this rule exists where the defendant can show a sufficient reason for not raising the issue in any prior post-conviction proceeding. Where, as here, a defendant appeals the circuit court's denial of a motion without, italicized, an evidentiary hearing. Then the question before us is narrow. Whether remand for a hearing is warranted because the circuit court erred in denying the motion on its face. Pursuant to blah blah, the court shall, quote, grant a prompt hearing, unquote, unless, quote, the motion in the files and records of the action conclusively show that the defendant is entitled to no relief, unquote. A Supreme Court has also determined, however, that a baseline level of the specificity applies to all post-conviction motions, including those under blah blah. Thus, in order for the reviewing court to meaningfully access the claim, the defendant must allege, quote, sufficient material facts, who, what, where, when, why, and how, that, if true, would entitle the defendant to the relief he or she seeks, unquote. This requirement promotes finality once the defendant has been convicted and sentenced, quote, minimizes time-consuming post-conviction hearings unless there is a clearly articulated justification for them, unquote, and recognizes that, quote, the pleading and proof burdens, have shifted to the defendant in most situations after conviction, unquote. Accordingly, a court, in the context of a blah motion, the defendant must describe with specificity, that's hard for someone with a lisp, specificity, his or her, quote, sufficient reason for, unquote, for failing to claim in any earlier proceeding. That is, the defendant must show why his or her claim is not procedurally barred under blah blah. Is there a there's a footnote. Of course, a defendant is not required to do so when there has been no prior post-conviction proceeding. We will further discuss some of the contours of this sufficient reason exception below, but one point bears mentioning here. Ineffective assistance of post-conviction counsel can be, and often is, cited as the reason for the defendant's not bringing some claim on direct appeal. The specificity requirement, however, applies just as much as in this context. The defendant cannot merely present legal conclusions, summarily arguing that post-conviction counsel was ineffective for failing to bring the claims he or she now views as meritorious. Instead, to be entitled to a hearing, the defendant must raise sufficient material facts demonstrating prior counsel's ineffectiveness. That is, and now we're on page 47 of 89, and I have been on for 2 hours. I should have brought up a bottle of water. That is a lot of reading. That counsel was constitutionally deficient and that such performance was prejudicial to the defendant. And what time is it now? 6:22 a.m. here in Chicagoland. Importantly, to show deficiency in this context, the defendant must allege sufficient facts showing that his or her new claim is clearly stronger than the claims post-conviction counsel in fact brought. Whether the circuit court erred in not ordering a hearing involves two potential inquiries with separate standards of review. The circuit court must hold a hearing where the motion is sufficient on its face, unless the record as a whole otherwise conclusively demonstrates that the defendant is not entitled to relief. Whether a Wisconsin motion meets this standard, including whether there is sufficient reason for overcoming the procedural bar of Escalano-Naranjo, is a question of law that we review de novo. If, on the other hand, the motion does not raise sufficient facts, quote, or presents only conclusory allegations, or if the record conclusively demonstrates that the defendant is not entitled to relief, unquote, then the circuit court has the discretion to grant or deny a hearing. In such case, we review for an erroneous exercise or discretion. Motion number 1, June 2017 motion. In August 2016, Avery, now represented by counsel, brought a motion for post-conviction scientific testing. In November 2016, the circuit court granted the motion, permitting Avery to conduct independent testing of 9 trial exhibits, 7 samples of bloodstain cuttings, swabs, or blood flakes taken from Halbach's RAV4, Halbach's RAV4 key, and a 1996 sample of Avery's blood. Based largely on the results of this testing and other investigations, Avery filed a motion in June 2017 requesting a new trial. His motion raises a number of claims, and the footnote for that says Avery reframes some of these claims and arguments on appeal, but our review is of the sufficiency of the underlying motion. We analyze that motion on its face, deeming new or newly argued issues forfeited. In addition, some of Avery's claims, such as his allegations of prosecutorial misconduct, are not reviewed on appeal. These we deem abandoned and will not discuss. These principles apply to our analysis of Avery's subsequent motions. Falling into 3 categories for purposes of overcoming the Escalano-Naranjo procedural bar. First, Avery alleges that trial counsel was ineffective for failing to fully investigate or present expert testimony in support of his theory that he was framed. Second, he brings several claims based on alleged Brady violations. Third, he raises claims based on the results of new investigations of a bullet, the hood latch swab of the RAV4, and the RAV4 key, all of which he characterizes as newly discovered evidence. The circuit court found that most of these claims were procedurally barred under Escalano-Naranjo because Avery had not alleged a sufficient reason for not raising them in his 2013 motion or on direct appeal. The court further held that the claims based on new scientific tests, when considered in the context of the full record, did not allege sufficient facts that, if true, would entitle Avery to relief. The court noted that the new reports on the bullet, hood latch swab, and key were equivocal in their conclusions and ambiguous. Therefore, quote, or therefore, given, quote, the totality of evidence submitted at trial, it cannot be said that a reasonable probability exists that a different result would be reached at a new trial based on these reports, unquote. Accordingly, the court denied Avery's motion without a hearing. We review the sufficiency of this motion de novo if we determine that Avery was not entitled to a hearing as a matter of law. We then review the circuit court's decision to deny him a hearing for an erroneous exercise of discretion. The first threshold step in this analysis is determining whether Avery has stated a sufficient reason for not raising these claims in his 2013 motion and on direct appeal. Ineffective assistance of trial counsel. Avery's claims relating to ineffective assistance of trial counsel are not and cannot be based on new or newly disclosed evidence unavailable to trial counsel. By definition, these claims are based on alleged errors of trial counsel, the argument being that Avery was thereby denied his constitutional right to counsel. As with any statute claim, Avery must show that there was a sufficient reason that these claims were not raised on direct appeal and in his 2013 pro se motion. And to establish a sufficient reason for not raising ineffective assistance of trial counsel claims on direct appeal, Avery must show that his new claims are clearly stronger than the claims post-conviction counsel actually brought. We begin by considering whether Avery has shown a sufficient reason for not having raised these claims in his 2013 pro se petition. We then turn to whether Avery has shown a sufficient reason for not raising these claims on direct appeal. It is at this point that the Scalano-Naranjo analysis dovetails with the merits of Avery's ineffective assistance of trial counsel claims, because if his new claims are facially insufficient as a matter of law, then post-conviction counsel cannot be ineffective for failing to raise them on direct appeal. Therefore, after we analyze the potential procedural bar of the 2013 petition, we turn directly to whether Avery's remaining claims demonstrate a reasonable probability that, but for trial counsel's unprofessional errors, he would not have been convicted at trial. Sufficient reason for failure to raise the claims in the 2013 motion. Now, mind you, in 2013, Stephen didn't have a lawyer. So I don't care what was in any filings in 2013. As a starting point, although Avery may argue ineffective assistance of post-conviction counsel as a sufficient reason for not raising these claims on direct appeal, that argument is not available to excuse failings in his 2013 motion. That is because Avery did not have a constitutional right to counsel following his direct appeal. As our Supreme Court recently observed, there is no constitutional right to counsel on a collateral attack, and subsequently, the vast majority of motions are filed by pro se litigants. The exception would swallow the rule if the mere assertion of pro se status were sufficient to overcome the procedural barrier of a Scalano-Naranjo. This legal point precludes successive post-conviction motions from turning into something akin to Russian nesting dolls, wherein a litigant can simply allege a continuous series of ineffective assistance of counsel claims to justify previous failures to raise an issue. Instead, where there are successive motions, any new motion must be based on something other than ineffective assistance of post-conviction counsel. Avery appears to recognize this point, foregoing any claim based on the mere fact that he was without counsel. Nonetheless, his June 2017 motion largely focuses on the quality of his self-representation, providing the following justification for not raising any of his current claims in his pro se 2013 motion. Numerous unique circumstances are present here that provide sufficient reasons the current claims were not previously presented. Mr. Avery had no way of knowing the factual and legal basis for the claims set forth herein. As a learning disabled indigent prisoner, Mr. Avery simply could not have known them. His attempt to file a meritorious pleading was thwarted by his lack of legal knowledge. The current motion is the product of over 1,000 hours of attorney time. My chair always leans to the side. The current motion is the product of over 1,000 hours of attorney time, hundreds of hours expended by private investigators, numerous consultations with experts, the expenditure of funds to retain those experts, and more. To expect an indigent prisoner acting pro se to compile a meritorious motion under these circumstances would be unreasonable. Mr. Avery's lack of legal knowledge, cognitive deficiencies, and the complexity of this unique case provide the sufficient reason that the current claim should be addressed on the merits. And that's the end of them quoting, the judge quoting Stevens' filing. Now we're back to the judge. Thus, we construe Avery to offer 6 somewhat overlapping explanations that, taken together, might provide a sufficient reason for not raising his claims in 2013. 1. He was unaware of the legal basis for the claims. 2. He was unaware of the factual basis for the claims. 3. He was acting pro se. 4. He was indigent. 5. He has a learning disability. And 6. This case is particularly complex. These explanations do not justify Avery's failure to bring the majority of his claims. I think they explain it all. Again, the quality of Avery's representation in his prior motion cannot in and of itself constitute a sufficient reason for not raising an issue earlier. Accordingly, we reject Avery's first argument that he, quote, lacked awareness of the legal basis for a claim. Unquote. Quote, lack of awareness of the legal basis for a claim, unquote, is a term of art that does not merely mean that Avery was not a lawyer or lacked legal knowledge. Rather, it means that he could not previously have anticipated a change, we're on page 52 of 89, in the substantive law that opened up a new basis for collateral attack. As to reasons 2 through 6, Avery gives us bare bones factual conclusions, but does not meaningfully explain why the circumstances. Sorry, I'm getting very fidgety from sitting here too long. He describes precluded him from raising most of these issues earlier. Regarding reason 2, unawareness of the factual basis of the claims, Avery does not explain, and we cannot envision why he did not have all the facts necessary in 2013 to raise these claims, which, after all, are premised on the further investigation of evidence and witnesses known to Avery at the time of trial. As to reason 3, as explained above, a defendant's pro se status, standing alone, cannot excuse his or her failure to raise claims in a motion. So it's your fault that you're not a lawyer? That you're not a lawyer, you're not smart, and you don't have money to hire a lawyer. So because you didn't do things right in court, that's your fault. It's just your fault. With one exception discussed below, Avery's remaining reasons are similarly deficient. Avery simply claims that he has a learning disability and was indigent in 2013, and that his case is complex. He does not cite any law or develop any detailed argument as to why these facts, alone or taken together, explain his failure to raise these claims. I hate our system. I hate our system. I hate our system. I don't like that you have to show that this happened in another case in order for you to bring it up in yours. Every case is different. And I shouldn't have to show you that this happened and was ruled on this way for this to just tell you this is what happened in my case. Hate it. I think it's a big waste of people's time and money. It appears well established from federal habeas law, from which we can borrow, that reasons such as these are not the sort of grounds on which a procedural bar can be avoided. Petitioner's pro se status, borderline mental retardation, and organic brain dysfunction did not provide sufficient cause to excuse procedural default of ineffective assistance claim. Cause must be based on an external impediment, unquote. The one exception we will recognize concerns Avery's contention that, on his own, it would have been impossible for him to have undertaken the extensive investigations later carried out by current post-conviction counsel, which resulted in new theories as to how he was framed and additional factual support for previous theories. For example, if Avery believed that forensic testing would have shown that his DNA was planted on the RAV4 key, he of course could have raised the issue in his 2013 motion. But to do so without any chance of success, he would have had to allege that post-conviction counsel was ineffective for not raising the ineffective assistance of trial is italicized, counsel claim on that basis, and to succeed on that italicized claim, that he would have had to show that this new claim was clearly stronger than those actually brought on direct appeal. Absent forensic testing supporting the basis for such a showing, this would be an all but important task. Thus, unique circumstances might exist wherein a pro se defendant is unable to perform or pay for an investigation, but later gains the resources to uncover new material facts and develop alternative theories of the crime, and on that basis can claim a sufficient reason for not previously raising claims based on those theories. We do not perceive the policies underlying Escalano-Naranjo, namely the need for finality in litigation, to preclude this result. Indeed, to hold otherwise could unfairly punish defendants who bring post-conviction motions based on all facts known to or reasonably discovered by them. For Escalano-Naranjo purposes, claims based on newly conducted investigations, which could not have been previously undertaken, would appear to be little different than claims based on newly discovered evidence. We will treat them as such in determining whether they are procedurally barred by virtue of Avery's prior pro se post-conviction motion. That said, the motion of Avery's ineffective assistance of trial counsel claims are not italicized, based on investigations that Avery, now represented by counsel, was only recently able to perform. And the footnote says, there was a number of claims, some of overlapping, that cannot be said to be based on new scientific or forensic experiments or investigations by Avery's experts, at which we therefore will not address except to list here. Several of these claims relate to issues that Avery's new experts did explore, and which we discuss in more detail below. But the claims in this list are not themselves dependent on the results of new investigations. Several of these claims also appear specifically to be based on some new test or experiment, such as a recreation with a key and a bookshelf. But crucially, these claims are not dependent on Avery's ability to hire new experts, spend money on new tests, etc. We are allowing Avery to overcome the procedural bar of his 2013 petition by demonstrating that he did not have the resources to earlier uncover the factual basis for his claims. But this cannot extend to simple experiments or recreations that require no expert contribution and or that could have been easily conducted at some point prior. And then the footnote continues on the next page. These claims are that trial counsel was ineffective for failing to 1. Cross-examine some of the state's expert witnesses instead of retaining their own. 2. Thoroughly investigate other suspects so as to identify a suspect meeting the requirement of State versus Denny. 3. Use available evidence supporting the theory that the RAV4 was moved onto Avery's property by the real killer. 4. Investigate Avery's pretrial relief that his blood was taken from blood drippings in his trailer sink and planted in the RAV4. This claim, standing alone, does not rely on new investigations. We discover related claims below. 5. Present a DNA expert's opinions about blood being planted in the RAV4. Avery does not indicate that current post-conviction counsel retained such an expert. Counsel did retain a blood spatter expert whose findings form the basis for other claims discussed below. 6. Demonstrate that Halbach's key was planted in Avery's bedroom by recreating how the key was found. 7. Demonstrate that the RAV4 key found in Avery's trailer was a sub-key or secondary key, as should have been evident from the 1999 Toyota RAV4 manual. 8. Detect and raise a Fourth Amendment challenge regarding DNA testing that allegedly violated the scope of a search warrant. 9. Investigate a chain of custody fabrication that allegedly allowed law enforcement to illegally collect and then plant Avery's DNA on the RAV4 hood latch. We discussed below claims based on the results of experiments on the RAV4 hood latch. 10. Present an expert on police practices and investigations who would have demonstrated errors in the handling of the investigation. 11. Conduct a simple experiment to demonstrate that a witness could not have smelled burning plastic, Halbach's electronics and camera, in Avery's burn barrel, as the witness testified to at trial. And 12. Investigate a variety of topics, all based on evidence known to counsel before trial. Avery also alleges that Halbach's ex-boyfriend was the real killer, but he does not present any cognizable claim based on this argument. That is, Avery speculates that the ex-boyfriend meets the Denny legitimate tendency test for introducing trial evidence that a third party committed the crime, but without pointing to any true newly discovered evidence, explaining why trial counsel rendered ineffective assistance during his Denny hearing in this regard, or otherwise demonstrating why such conclusion entitles him to a new trial. Done with the footnote. So now I can go back to what I was reading. Okay. On the other hand, we have identified 7 claims, all premised on the results of forensic testing, that could conceivably fall in this category. So as to address as nearly all allowable the merits of his motion, we will assume that Avery has alleged a sufficient reason for not raising these 7 claims in his 2013 motion. These claims are that trial counsel was ineffective for failing to 1. Present a blood spatter expert who would have found that Avery's blood was planted in the RAV4. 2. Present a blood spatter expert who would have found that Halbach was not thrown in the rear of the RAV4 after being fatally injured. 3. Present a blood spatter expert who would have determined that the theory counsel presented at trial as how Avery's blood was planted in the RAV4 was untenable. 4. Present a trace materials expert who would have found that the RAV4 key uncovered from Avery's bedroom was Halbach's sub-key or secondary key. 5. Present a DNA expert who would have found that Avery's DNA was planted on the sub-key by law enforcement. 6. Present a DNA expert who would have found that Avery's DNA was planted on the RAV4 hood latch. 7. Present a forensic fire expert who would have found that Halbach's body was not burned in Avery's burn pit. CN. I have it posted in another post here on Stephen Avery Project. This is the state's response asking Judge Flowers to deny Stephen for getting any post conviction hearing, trial, relief, anything. So I've been reading that for the last 2.5 hours now. Okay. Merits of Avery's claims of ineffective assistance of trial counsel. We now turn to whether Avery's ineffective assistance of trial counsel claims have alleged, quote, sufficient material facts, who, what, where, when, why, and how, and if true, would entitle him to the relief he seeks, unquote. Bearing in mind that he is not entitled to a hearing where the record conclusively demonstrates otherwise. In short, Avery must show that a hearing would not be frivolous. Avery cannot make this showing. First, he has wholly failed to demonstrate deficient performance, that trial counsel's, quote, representation fell below. You're welcome. By counsel's not retaining experts similar to those he later retained. Avery apparently assumes that his findings speak for themselves and that given the strength of his later claims, the necessity for such experts should have been obvious at the time of trial. And another footnote, which says, relatedly, Avery fails to demonstrate how the defense strategies that trial counsel did pursue rendered counsel's performance constitutionally deficient. As an example, he points to trial counsel's failure to obtain a blood spatter expert, but does not address why counsel's chosen strategy for explaining the presence of his blood in the RAV4 represented deficient performance, and now this is italicized, at the time of trial, without the benefit of hindsight. This is a repeated shortcoming in Avery's briefing, both to the circuit court and on appeal, and represents exactly the type of Monday morning quarterbacking that we strive to avoid in evaluating a claim of ineffective assistance of counsel. What he would have done differently had he conducted the defense at time of trial, our court has called this hindsight is better than foresight approach to be Monday morning quarterbacking, and has made clear that, it is the right of a defendant and trial counsel to select the particular defense from among the alternatives available upon which they elect to rely, unquote. It is all too tempting for a defendant to second-guess counsel's assistance after conviction or adverse sentence, and it is all too easy for a court examining counsel's defense after it has proved unsuccessful to conclude that a particular act or omission of counsel was unreasonable, unquote. Now back up to before the footnote. Avery also assumes again without explanation that any experts retained by trial counsel would have reached the same conclusions in his later experts. But even accepting these premises, Avery has not demonstrated prejudice, that, quote, there is a reasonable probability that, but for counsel's unprofessional errors, the result of the proceeding would have been different, unquote. Avery's first three claims concern trial counsel's failure to retain a blood spatter expert. Avery argues in his motion that counsel was ineffective because such an expert would have found that his, quote, blood was planted in the RAV4, unquote. His retained expert's actual findings, however, are not nearly so conclusive. The expert did not conclude that Avery's blood was planted or rule out Avery as the source of the blood. Rather, he determined that the presence of Avery's blood was, quote, consistent with being randomly distributed from a source because his blood is present in some locations but absent in some other reasonably anticipated locations, unquote, and that, quote, the absence of blood stains in these locations is inconsistent with an active bleeder, unquote. The state alleged at trial that Avery's finger was actively bleeding while he was in the RAV4. The expert further determined that the bloodstains were, quote, consistent with an explanation other than Mr. Avery being in the RAV4 and depositing his blood in those locations with his actively bleeding cut finger. And another footnote, which says, for the purpose of this motion, we accept that these conclusions are based on sound methods. It is unclear, however, how this expert determined that a person actively bleeding in the RAV4 would have left a different blood pattern than what was found at Halbach's vehicle. According to the expert's affidavit referenced in the June 2017 motion, he recreated how blood could be taken from Avery's sink and selectively planted in the RAV4. That June 2017 motion states that presumably some different, quote, blood spatter experiments conducted with actual blood on the subject's middle finger exclusively demonstrate that the blood would have been deposited on, unquote, additional locations with the RAV4. The experiment is not described in the referenced affidavit, however, so we do not know the methodology supporting this conclusion. So back up before the footnote. Where is it? Where's the footnote? This is all like... Where's the footnote? Oh, there it is. Thank you, Alicia, for answering. Certainly, these conclusions tend to support Avery's general theory. What I'm reading right now, by the way, for people that are just tuning in right now, so the beginning of this video, 2.5 hours ago, is where I was reading the state's response. What I am reading now, the state has included this in their response. This was the court's last response prior to this, because they're citing all this to explain why they shouldn't be able to bring it up again. So this stuff I'm reading now is from the court, but it's old. We are now going to have to wait for the court to respond to what the state filed, which is what I read 2.5 hours ago. But we all know Judge Flowers is going to deny it. All right, let me go back to where I was. Next, Avery argues that counsel was ineffective because a blood spatter expert would have refuted the state's narrative that Halbach was thrown in the rear of the RAV4 after being fatally injured. Avery asserts that, to the contrary, Halbach, quote, was struck on the head after she opened the rear cargo door, unquote, and was then, quote, struck repeatedly by, unquote, a mallet or hammer, without explaining why an alternative finding as to how she was killed supports his theory that he was framed. Third, Avery contends that a blood splatter expert could have advised counsel that his trial strategy for explaining the presence of his blood in the RAV4 was flawed. Example, that such strategy would have failed to persuade the jury. This assertion is entirely speculative. As a matter of law, such guesswork falls well short of demonstrating ineffective assistance of counsel. Fourth, Avery argues that counsel was ineffective for not retaining a trace materials expert who would have found that the RAV4 key recovered from Avery's bedroom was Halbach's secondary key or subkey. But it is, again, completely speculative to assume that the subkey was therefore planted, and not instead that Halbach herself was using her subkey and not her main key on the day of her death. Okay. No, I mean, I know I'm already 2.5 hours in, but I have to go into stuff that I've said a million times about the keys. Correct, Cian. Multiple people testified that Teresa Halbach was extremely paranoid about losing her keys. That was the whole purpose of that lanyard that her sister gave her, that she could wear her keys around her neck. So therefore, why would she only be carrying one of her keys? Somebody who is worried about losing their keys does not, for one, use their valet key. Where's her house key? Where's her office key? She's keeping all her keys separate, so there's multiple sets of key rings she has to keep track of? So are you saying maybe she leaves her house unlocked? You know, because she was living with a boy that, don't apologize for swearing, Sienna. I've got the worst mouth ever. She was living with Scott Blodorn, who she was also having sex with. Okay. And the house is on her parents' property with her parents next door. I've also done videos showing you, we've gone to her house and shown you how far apart her house was from her parents' house. So maybe she left her house unlocked. Maybe she doesn't need to carry her house key. Does she leave? Is the photography studio left unlocked? I doubt it. I highly doubt that you're leaving a photography studio unlocked. Where's the studio key? The girl was afraid of losing her keys. Her friend testified to that. Her friend that she had just gone on a vacation with in August. Her sister testified to that. And the dude, Tom Pierce, that owned the photography studio, all talked about her being paranoid about her keys. So then why did she only have one key? It's her spare key, because her keys have never been found. All right. Sorry. Avery's fifth and sixth claims concern the retention of a DNA expert. According to Avery, such an expert would have determined that his, quote, DNA was planted on the key, unquote, by law enforcement. Avery again misstates the evidence. His expert analyzed DNA from, quote, an exemplar key reportedly held by Mr. Avery as if to start a car, i.e., gripped by ungloved fingers for 12 minutes, unquote. The expert determined that 10 times less DNA was deposited on the exemplar key than on the key recovered by law enforcement. The expert further concluded that, quote, if the key was indeed enhanced, i.e., tampered with, then it is likely that some ... personal item of Mr. Avery's was used for this purpose, such as, quote, a toothbrush or cigarette butt, unquote. Thus, once again, the findings of Avery's expert are significantly more ambiguous than what is presented in his motion. We have no reason to doubt the truth of these findings, although we note that the expert did not observe Avery holding the key, but simply determining that Avery deposited significantly less DNA in a controlled experiment does not indicate that Avery could not or did not deposit more DNA under other conditions, and it certainly does not demonstrate that law enforcement planted DNA on the key. Thus, even accepting the truth of these new findings, we cannot conclude that there is reasonable probability that their introduction at trial would have led to a different result. Is he wearing gloves? Is he not wearing gloves? Is he bleeding profusely? Is he not bleeding profusely? Why is there no blood on the key? Why is it sweat on the key? Why is there no Teresa Halbach DNA on the key? A girl who regularly drives, basically drives for a living, going around taking pictures, key in her hand, key out of her hand, key in her hand, out of her hand, turning the key, turning the key, turning the key. Why no Teresa Halbach DNA and only Stephen Avery DNA on that key? Because it was cleaned, and then Stevens planted on there. By who? By whom? Whatever is the correct grammar. I don't have to prove who put the DNA on there, but somebody put the DNA on there, and it wasn't Stephen Avery. His fingerprints are nowhere. His fingerprints not on the key. His fingerprints not on the car. Why aren't there fingerprints? Oh, he had gloves. But if he had gloves, then how is there other DNA on there? You can't have it both ways. Joe, I believe that Scott Blodorn, Ryan Hilgas, and Michael Halbach provided Manitowoc with the spare key. Um, okay. Avery's sixth claim is that counsel was ineffective for not retaining a DNA expert who would have determined that DNA from Avery's sweaty hands, quote, was never deposited by Avery on the RAV4 hood latch, unquote, demonstrating that, quote, Mr. Avery was being framed, unquote. In what is becoming a pattern, Avery has misrepresented the facts. The DNA expert Avery has now hired did not, italicized, determine that Avery never deposited the DNA and did not, italicized, state that Avery was framed. Instead, the expert performed a series of experiments on an identical vehicle wherein volunteers opened the car hood using the hood latch. Only 4 of the 15 volunteers deposited DNA, and those 4 deposited significantly less DNA than present in the swab from Halbach's RAV4 hood latch. From this experiment, the expert extrapolated the possibility that law enforcement could have retrieved and relabeled a swab of Avery's groin, which was collected and discarded, I should add, allegedly, for exceeding the scope of a search warrant, as coming from the hood latch. The expert admitted, however, that, quote, the convenience of this explanation, ... and the fact that it accounts for the physical findings observed from the analysis, ... does not prove evidence tampering or, more precisely, evidence reassignment, unquote. Thus, again, we are left with facts that, even if true, would not entitle Avery to relief. In a controlled experiment, the minority of volunteers who deposited sweat on the RAV4 deposited significantly less sweat than on the swab recovered by law enforcement. Now we're on page 61 of 89. There is no context to these findings, no showing of why Avery, under uncontrolled conditions, could not have deposited more sweat than the volunteers, much less any showing that the DNA was therefore planted. Without such context, this evidence is not exculpatory or even particularly relevant, and Avery's attempt to link it to the alleged reassignment of his groin swab is wholly unsupported by any facts of record. What does this mean for Stephen? It leaves Stephen the same place as always. Now, you wait for this court to deny it and then try to take it to another court. That court will most likely deny it, lather, rinse, repeat. For Brendan, none of this does nothing for Brendan. Brendan is a separate case based on separate facts. So anything that happens in Stephen's case really has no effect on Brendan. All right, back to reading. Avery's seventh and final claim is that trial counsel was ineffective for not presenting a forensic fire expert who would have found that Halbach's, quote, body was not burned in the Avery burn pit and that her bones were therefore planted, unquote. Avery cited factual support once again does not live up to the advance billing. His forensic fire expert did state that he, quote, disagreed with the state expert's opinion that the main destruction of the body took place in, unquote, the Avery burn pit. But Avery does not explain why, from this conclusion, it follows that Halbach's remains were planted, because he does not explain why he himself would have been unable to cremate some portion of Halbach's body in another location, including in his burn barrel, where additional bone fragments were found. More important, Avery does not explain where or how prejudice arises, given that his own forensic anthropologist testified to the same conclusion at trial. Avery's expert further concluded that, contrary to the state's theory at trial, Halbach's body could not have been burned to the extent it was burned in only 4 hours. Again, this is a fact without context. At most, it's science. Presenting such evidence at trial, which could have enabled the jury to weigh two competing expert opinions on how Halbach was cremated. Avery again has presented no reasoned basis for concluding that the outcome of trial would have been different. Nobody can say they would know how a jury is going to decide something unless you take it to a jury. You don't know. Nobody knows. State doesn't know. Defense doesn't know. Nobody knows. In sum, the 7 ineffectiveness claims in Avery's June 2017 motion that are based on new investigations fail on the merits. Avery has not shown that trial counsel provided objectively deficient representation by not hiring experts to those he later hired. Instead, Avery merely assumes that the need for such experts should have been obvious at the time, based on the later findings of his own expert. These later findings, however, are either equivocal, irrelevant, or both. In addition, Avery has not explained how these findings would have negated or undermined the cumulative effect of the other trial evidence. Thus, Avery has failed to show that, even if these findings were admitted at trial, the result would have been different. Consequently, Avery has not alleged sufficient material facts entitling him to a hearing on his claims of ineffective assistance of counsel. Next section is titled Brady Violations. And now remember, this is all from Judge Flowers from years ago, her prior ruling, not what's going on now. Avery argues that the state withheld favorable evidence in its possession in violation of Brady. He first alleges that state suppressed a voicemail recording that Halbach left on the answering machine of her photography client, whom she met on the same day that she visited Avery's property. Next, he alleges that the state withheld an unedited video of flyover footage of Avery's property, and instead released to Avery an edited version with just 3 minutes of footage. Finally, Avery argues that, quote, investigators concealed their knowledge that Halbach's RAV4 was driven onto, unquote, the property of Avery's next-door neighbor. Avery does not claim that these alleged Brady violations were unknown and undiscoverable at the time of his 2013 motion or on direct appeal. His given explanation for not raising any of his new claims in 2013 is general and relates to his status as a pro se prisoner litigant. His explanation for not raising his new claims on direct appeal does not reference the Brady claims. Thus, Avery has not overcome the procedural bar of Escalano Naranjo by demonstrating a sufficient reason for not raising his Brady claims earlier. Get fucked. I'm sorry, it bothers me so much that you want to blame him when he acted as his own attorney. That he didn't do this, that, and the other. It's already stated, he's not smart, not a lawyer. He's in prison. He doesn't have access to any experts or money. So you can't say, since he didn't do this in 2013 and he did this wrong in 2013, can't do anything about it now. Bullshit. Bullshit. In any case, Avery's June 2017 motion does not sufficiently allege any Brady violation. Quote, a defendant has a due process right to any favorable evidence, material either to guilt or to punishment, that is in the state's possession. Unquote. A defendant is entitled to a new trial based on the denial of such right by showing that 1. The evidence is favorable to that defendant, either because it is exculpatory or impeaching. 2. The evidence was suppressed by the state, either willfully or inadvertently. And 3. The evidence is material. The standard for materiality is the same as under the prejudice prong of Strickland. Quote, evidence is material only if there is a reasonable probability that, had the evidence been disclosed to the defense, the result of the proceeding would have been different. Unquote. Avery has not demonstrated any of the above elements for any of his claims, but what is clearest on its face is that this evidence, where it even exists, is immaterial. Avery has not demonstrated any of the above elements for any of his claims, but what is clearest on its face is that this evidence, where it even exists, is immaterial. Avery's first claim centers on the fact that on the day Halbach visited his property, she left a voicemail that she could not locate the residence of one of her other photography clients, whom she also visited that day. Avery argues that had this voicemail been played at trial, it would have, quote, refuted the theory that Halbach's final appointment was with Mr. Avery, unquote. At trial, however, the photography client testified that after Halbach left the voicemail on the client's answering machine, she found the client's house, took photographs, and left within 15 minutes. Then, approximately 20 to 30 minutes after Halbach left the voicemail, as established through her phone records, other witness testimony placed her as driving to and then on Avery's property. The voicemail is therefore consistent with the evidence, which is that Halbach left a voicemail, visited a client, and then visited Avery's property. There is no basis for Avery's assumption that the content of the voicemail would have refuted the state's theory about when or how Halbach was killed. Avery's next claim is that he received an edited version of a flyover video of his property that may have contained favorable evidence. As far as we can tell, this claim is based only on Avery's unsubstantiated belief that a second video must exist because the airplane was in the air for 4 hours, but the video he received was only 3 minutes long. There is no evidence of a Brady violation here because Avery merely speculates that evidence not even known to exist was suppressed. So they fly for over 4 hours, but only film for 3 minutes. Sure. Finally, Avery argues that investigators knew but did not disclose to him that Halbach's RAV4 was driven onto the property of Avery's next-door neighbor. It is difficult to follow this argument, but it is based on an affidavit from the neighbor, who does not italicized, state that the RAV4 was on his property, but rather attests to a conversation with law enforcement agents in which they stated their belief as to how Halbach's vehicle was driven onto Avery's property, presumably after Halbach's death, but the agents could have been referencing to Halbach's driving route on the day of her death. Avery suggests that the information in the affidavit supports his claim that law enforcement framed him for the crime by driving the RAV4 through the neighbor's property and planting it on his. This argument is unintelligible, and in any case, we cannot perceive any Brady violation. There was no evidence here to suppress, and the facts in the affidavit are inconsequential. Next section is titled Newly Discovered Evidence. Finally, Avery raises two, which there's a footnote for that one. The footnote says a third claim repackages one of Avery's ineffectiveness claims, arguing that the results of the experiment with the RAV4 hood latch, wherein volunteers touched an identical RAV4, which was then swabbed and tested, constitute newly discovered evidence. Avery cannot have it both ways. Above, we assumed for the purpose of this motion that trial counsel's failure to obtain such results might constitute ineffective assistance of counsel. We will not now analyze a claim based on the premise that these same results were undiscoverable at the time of trial. In any case, it seems evident that trial counsel could have performed this simple experiment, so it is not apparent how the results of this experiment could constitute newly discovered evidence. All right, back up. Claims based on newly discovered evidence. He contends that, quote, new evidence demonstrates that the damaged bullet ... in Mr. Avery's garage was not shot through Halbach's head, causing her death, unquote. He also argues that, according to new tests, the swab labeled as coming from Halbach's hood latch containing Avery's DNA was not, in fact, taken from the hood latch. And there's a footnote on that that says this claim is based on different evidence than forming the basis for Avery's ineffective assistance claim on the same issue. In theory, a defendant should be able to more easily overcome the Escalona Naranjo procedural bar when basing claims on newly discovered evidence, which, after all, concern evidence not available in prior proceedings. This is not the case here, however, as is demonstrated by simply turning to the merits of Avery's claims. To obtain a new trial based on newly discovered evidence, a defendant must show that, quote, 1. The evidence was discovered after conviction. 2. The defendant was not negligent in seeking evidence. 3. The evidence is material to an issue in the case. And 4. The evidence is not merely cumulative, unquote. If the defendant meets these criteria, then the circuit court must determine, quote, whether a reasonable probability exists that a different result would be reached in a trial, unquote. To be entitled to a hearing on post-conviction claims of newly discovered evidence, the defendant must allege sufficient material facts satisfying these elements. Avery cannot meet one or more of these elements for either of his claims. As a threshold matter, he has not shown that his purportedly new evidence is, in fact, new. Avery asserts that the equipment yielding his test results was previously unavailable, was new technology, and or was manufactured in 2016. But aside from these cursory statements, Avery does not address whether technology available at the time of trial could have yielded the same results. And the footnote for that says, for example, the state points out that its trace expert at trial used the exact same technology and performed the same type of elemental analysis on charred bone fragments before trial that Avery's expert performed in 2017. Both experts used a, quote, scanning electron microscope with an energy dispersive X-ray analyzer, unquote, for their analysis, and there is no statement in the affidavit of Avery's expert as to why his test could not have been performed in 2006. All right, back up before the footnote. Beyond that, Avery's evidence is largely irrelevant. The premise of his first claim is that if the damaged bullet found in his garage did not deliver Halbach's fatal shot to the head, then he could not be the perpetrator. But the state never argued that either of the bullets recovered from Avery's garage killed Halbach. At trial, the state showed that Avery's gun fired the bullet and that the bullet had Halbach's DNA on it. But the state did not argue that this specific bullet entered Halbach's skull or killed her, nor was it necessary that it do so in order to implicate Avery in her murder. There is nothing to suggest that shots fired into Halbach's skull were the only shots fired at her, or that every bullet fired at her contained skull fragments. There were, after all, 11 casings and only 2 bullets found in the garage. The presence of Halbach's DNA on a bullet found in Avery's garage is particularly damning evidence. Regardless of whether it was the bullet that entered her skull, and strongly implicates Avery absent evidence that Avery's DNA was planted, a supposition that even now Avery has done little to develop. At the very least, Avery's new evidence, if it in fact is new, is consistent with the state's theory of the crime. I'm going to show my ignorance here. All right. I'm not a gun expert. I'm not even a pro gun person, but I'm married to somebody who is. My husband is a firearm instructor, teaches concealed carry, is a gun enthusiast, and I'm always confused a lot on gun terminology and such. And I know it's something that gun people like to own the libs on, that we don't know the words of things. So correct me if I'm wrong, and I know my husband is sleeping right now, so he can't correct me. But a bullet isn't fired, right? The bullet isn't fired. The casing is what happens from a fired bullet. So for there to be Halbach DNA on a bullet that hasn't been fired makes no sense. There should only be DNA, the victim's DNA on a casing, right? Are you guys following me on that? And please, people, gun people, go ahead and correct me. So if a bullet enters a skull, you then just get a casing, right? That's how this works. And you have no proof then. You're saying this bullet has Teresa Halbach's DNA on it, but it didn't go through a skull, yet you're claiming she was shot in the skull. And I know this is something my husband and I went over years ago too, about this Glenfield Marshall rifle, and if that's even able to go into somebody's skull. It's like a starter gun. It's one of the most average gun, that 22. Carol, the casing is what stays in the gun after the bullet is fired? I didn't know anything stays in the gun. I thought everything left the gun. Because the thing ejects, right? I'm so confused. I'm going to have my husband demonstrate all this stuff for me again. I should write a note because I'm going to forget, since now, I've been up since, I don't know if it was 2 or 3 a.m. and started doing this at 4 a.m. Gun demo. Writing that down. I want my husband to show me this stuff. And I know we've gone over before, like I said, to gets ejected out unless it's a revolver. Thank you, Carol. Um, that a 22 is not very powerful. Um, right, Joe, that's what I'm confused about right now. Did they find bullets or casings? Because now Judge Flowers is saying both bullets and casings. So I'm confused. Um, I guess we could go. I'm not going to do it now because I've already been doing this for 3 hours and we're on page 67 of 89 still. But on StephenAveryCase.org, I think it's .org. I can never remember if .org or .com is a good one, but it has the evidence list. Are there casings, bullets, or both? I'm confused. Okay, let me go back to reading this. My family's going to have fun with my family is celebrating Thanksgiving today. So now here I've been up since 2 reading this for 3 hours and I have to be at my family at 3 o'clock this afternoon to celebrate Thanksgiving. Will I get any sleep? Will I be really crabby? You make the call. Okay. Back to reading. Avery next argues that his expert observed the hood latch swab and determined that, quote, swabs collected from the hood latches of 2 exemplar vehicles, a 2012 RAV4 and a 2007 Volvo S60, each slowed a considerably heavier loading of debris, unquote. Let me see. Dave says it's the bullet that does the damage, i.e., the lead, not the casing. Thank you, Dave. The expert apparently reached this result, however, by observation alone, concluding that, quote, whereas particles on the RAV4 hood latch swab, ... could only be seen with the aid of a microscope. A swab from each exemplar vehicle showed a heavy dark streak of collected debris that is clearly visible to the unaided eye, unquote. Let me read what Gwen said now. Once a bullet is propelled out of the gun from the reaction, the casing is ejected from the gun using an ejector and extractor. This allows for the next round to be loaded and ready to fire with the pulling of the trigger. And I know it's something that my husband, when we watch shows and or movies, and why John Wick is, I love the John Wick movies. Oh my God, I'm so excited. There's another one coming. But he always calls bullshit when you don't hear the brass. And I know when I've gone to a range with my husband, he'll refer to me as his brass chicken, because my husband reloads. And so when he shoots, I then pick up the brass, which dummy me at times have picked it up and it's still hot. That has now been ejected. I pick it up and put it in a bag because he then reloads it with gunpowder to use it the next time he goes to the range. So, so it's a big thing on that the brass ejects. Okay. We are left to wonder how new testing methods or equipment could possibly aid this analysis. In any event, the expert did not determine that the purported RAV4 swab, quote, was not used to swab the hood latch, unquote, as Avery claims, much less that this swab was reassigned or otherwise used to frame Avery. There is no possibility that the presentation of this evidence could have yielded a different trial result. Conclusion as to the June 2017 motion. Because Avery has not shown that he is entitled to a hearing on any claim, we review the Circuit Court's denial of a hearing for an erroneous exercise of discretion. We find that the court did not err in this regard. We agree with the court's assessment that had Avery's equivocal and ambiguous conclusions been introduced at trial, there would have been no reasonable probability of a different result. The circuit court appropriately exercised its discretion. We have given Avery the benefit of several doubts as to why he did not raise these claims earlier. Even considered on the merits, the claims asserted in his June 2017 motion are speculative, conclusory, and in some cases misleading. The Circuit Court did not err in denying these claims without a hearing. Motion number 2, October 2017, motion for relief from order. 3 days after the Circuit Court denied his motion, Avery filed a motion for relief pursuant to statute blah blah blah. The stated basis for the motion was that a month prior to the court's order, defense counsel and prosecutors had agreed to additional testing of Halbach's RAV4 and of bones found in the Manitowoc County gravel pit, that the parties had agreed that Avery would amend the June 2017 motion, and that Avery, quote, intended to inform the court of an amended motion would be filed, unquote, but, quote, did not anticipate the court filing its order, unquote, before he could do so. And the footnote says, on appeal, Avery implies that the state misled him about the need to oh my God, that's a big word, expeditiously inform the circuit court of his wish to amend, supplement the June 2017 motion. For example, Avery states, quote, when current post-conviction counsel inquired as to whether the circuit court should immediately be informed of the agreement, the prosecutor stated that once he had finalized the scheduling of the RAV4 examination, a stipulated order could be presented to the circuit court, unquote. This statement appears to be Avery's counsel's own uncorroborated description of events. There is no basis in the record for this or any related argument that the state misrepresented the post-conviction process. In any case, as the circuit court explained, the state cannot determine whether and how motions to the court are amended or supplemented, and Avery had no grounds for assuming otherwise. Moreover, this argument was not presented to the circuit court and is thereby forfeited. The circuit court denied the motion, explaining that after receiving the June 2017 motion, quote, no communication, unquote, was made, quote, requesting that the court withhold its final decision or indicating that the original motion was incomplete and would be supplemented, unquote. The court acknowledged that the defense and prosecution might very well have discussed amending the June 2017 motion in anticipation of the court's granting a hearing, but, and now this is a citing that, this section here is citing what they were just talking about. The court was not informed of any such negotiations until after the final ruling in this matter had been issued. None of the agreements were submitted to the court for its approval until the final decision was made in the defendant's original motion. It is for the court and not the parties to determine if amendments to motions previously filed will be permitted and to establish scheduling for matters pending before it, Agreements should have been submitted for approval of the court prior to the final decision on the original motion being reached. The defense cannot try to amend a motion that was filed without reservation only after it receives an adverse ruling. Now back to Judge Flowers. Wisconsin statute provides that the court, quote, may relieve a party, from a judgment, order, or stipulation for, mistake, inadvertence, surprise, or excusable neglect, unquote. We review the circuit court's decision on a motion for relief under blah blah for an erroneous exercise of discretion, meaning we will sustain the court's ruling where it applied the appropriate law to the facts on record as to, quote, achieve a reasoned and reasonable determination, unquote. As explained above, a movant is not entitled to an evidentiary hearing merely because he or she filed a motion. In the typical case, the circuit court will evaluate the facial sufficiency of the motion before ordering the state's response or scheduling a hearing. Thus, circuit courts routinely receive and deny motions where there is no basis for a hearing. As one would expect, courts are not required to, and generally do not, update the movant about when a decision on the motion is forthcoming. Avery appears to acknowledge these basic principles of post-conviction procedure. Nonetheless, he argues that the circuit court erroneously exercised its discretion here because in denying his motion for relief, it ignored the existence of a 2007 order. And the footnote says, the state argues that this argument was forfeited because it was raised for the first time on appeal. We agree that, at the very least, the argument was not very well developed below. For completeness, however, we will exercise our discretion to address this argument on the merits. All right, back up. This 2007, quote, order on preservation of blood evidence and independent defense testing, unquote, directs the state to preserve swabs and blood stain samples collected from the RAV4 and containing Avery's DNA, and allows such items to be submitted for independent testing, quote, without further order of this court, unquote. Avery's argument with respect to the 2007 order misses the mark entirely. Even if, is italicized, all of the items the parties contemplated testing in 2017 had been described in this order, the order has no bearing on the presentation, timing, or amendment of any Wisconsin motion. This circuit court correctly concluded that it was not required to revisit its decision on the June 2017 motion upon being belatedly informed that Avery wished to amend that motion. Thus, the court did not erroneously exercise its discretion in declining to vacate an order adverse to Avery so as to allow amendment of, quote, a motion that was filed without reservation, unquote. Motion number 3, and now we are on page 71 of 89, and I've been on here for 3 hours and 15 minutes. Holy crap. October 2017, motion for reconsideration. Shortly after filing his motion, Avery filed a motion to reconsider. Footnote for that says, the motion to reconsider was followed by several subsequent supplements in which the motion was revised. For convenience, we discuss these as a single motion. Back up. As relevant to this appeal, and now back down for another footnote. In addition to the arguments addressed in this section, Avery's motion for reconsideration argues that the circuit court made manifest errors of fact and law in denying his June 2017 motion. We review the June 2017 motion in the first portion of this decision and conclude that the court did not err. Of course they would say court didn't make any mistake. Nope. Except as noted in this footnote. Therefore, we address in this section only those arguments based on claims of newly discovered evidence. In its decision on the June 2017 motion, the circuit court mischaracterized Avery's allegations relating to ineffective assistance of post-conviction counsel. Avery raised these allegations so as to explain why his claims were not procedurally barred by Escalano Naranjo. That is why he did not raise his claims on direct appeal. The circuit court misconstrued Avery to allege ineffective assistance of appellate counsel and concluded that Avery was required to file a Knight petition with this court in order to correctly points out, in order to do so. On appeal, Avery correctly points out that this was an error. Regardless, our review of the sufficiency of the June 2017 motion is de novo, and we conclude that Avery did not demonstrate ineffective assistance of post-conviction counsel. Therefore, the circuit court's error was harmless. Oh, of course, court's mistakes are harmless. All right, back up. Where was I before the post said? Okay. He alleged alleges that duly discovered evidence warrants reconsideration of the court's denial of his June 2017 motion. A party may prevail on a motion for reconsideration by presenting newly discovered evidence, but such motion is not a platform, quote, to introduce new evidence that could have been introduced, unquote, as part of the original proceeding. The term newly discovered presupposes that the evidence was unknown at the time of final judgment. That is, it was not under the control or knowledge of the movant or discoverable by reasonable diligence. Quote, we review a trial court's decision on a motion for reconsideration under the erroneous exercise of discretion standard, unquote. A motion to reconsider on the basis of new evidence would seem to be of doubtful utility in cases like this, where the movant is free to file successive motions. Nonetheless, we perceive no legal barrier to Avery's bringing such a motion. My nose itches. And the state does not argue as much, except to point out that this motion cannot be the means of avoiding the procedural bar of Escalano Naranjo. In this context, to be entitled to reconsideration on the basis of newly discovered evidence, the movant must show that the evidence was unknown and not reasonably discoverable when the first motion was filed, and that the evidence reasonably relates to those claims brought in the first motion. Alternatively, the movant may simply bring a new motion and demonstrate his or her sufficient reason for not raising the claim in the prior motion by showing that the evidence underlying that claim was then unknown and not reasonably discoverable. Avery makes no showing in his motion to reconsider as to why he could not, with reasonable diligence, have included this new evidence in his June 2017 motion. Instead, he uses this third motion as a vehicle for raising new claims. None of these claims or evidence, however, have any bearing on the claims raised in the June 2017 motion, so it is unclear which original, italicized, claims the circuit court was being asked to consider, or why. In any case, the majority of this evidence cannot reasonably be considered unavailable or undiscoverable at the time Avery filed his June 2017 motion. Holy crap, the footnote for this one is long. All right, here we go. Avery's motion for reconsideration raises claims based on evidence that cannot reasonably be considered newly discovered, i.e., unavailable and not discoverable through reasonable diligence at the time of the June 2017 motion. Therefore, we will not address these claims further, except to list and briefly discuss them here. We will not address these further except to talk about them here. Okay, whatever, that confuses me. These are that one, the state withheld evidence that Halbach's vehicle was seen on the street days after disappearance, claim based on 2017 affidavit of witness attesting that in 2005 he observed a vehicle matching a missing person's poster description of Halbach's car and informed law enforcement of that fact, but with no showing that Avery was unable, through reasonable diligence, to discover this information prior to filing the June 2017 motion. 2. Trial and post-conviction counsel were ineffective for not presenting impeachment testimony on key witnesses, or in the alternative, the state violated Avery's right to due process by knowingly using false testimony at trial, claims based on evidence collected at the time of Halbach's disappearance and presumably known to Avery at the time of trial, with no representation that Avery learned of this evidence only after filing the June 2017 motion and could not reasonably have discovered it earlier. 3. There is another possible suspect meeting the Denny test, claim based on evidence showing how long it takes to drive away from Avery's property. 4. There is another possible suspect meeting the Denny test, claim based on evidence gathered by examining images found on a computer. Avery states the computer search was the result of 2017 technology, but does not explain whether technology available earlier would have uncovered these images, or why, through reasonable diligence, he could not have uncovered these images prior to filing the June 2017 motion. 5. Alleged Brady violation based on 2005. These on 2005 evidence purportedly withheld concerning who might have had possession of Halbach's day planner after her death. Avery does not explain when he received this evidence or why it was not reasonably discoverable prior to June 2017. 6. There is another possible suspect meeting the Denny test, claim based on statements made to police in 2005 about Avery's sister, and not Avery, requesting that Halbach photograph a car on Avery's property, but with no showing that this evidence was unknown or not reasonably discoverable prior to June 2017. 7. There is another possible suspect meeting the Denny test based on evidence that Avery's sister attempted to hide files on her computer that might link her son to the crime. This information was reported to the police prior to trial, and Avery does not allege that he was unaware of this evidence at trial or explain why the evidence was not reasonably discoverable prior to June 2017. Motion number 3 also contains arguments that are the subject of motion number 4, and which we will therefore discuss in the following section. Because these claims were brought in a motion to reconsider, we conclude only that the Circuit Court did not erroneously exercise its discretion in declining to revisit the June 2017 motion in light of the content of this motion. Neither we nor the Circuit Court have squarely considered whether these claims are procedurally barred under Escalano-Naranjo, or whether Avery pled sufficient material facts entitling him to a hearing, although our analysis overlaps with the former inquiry. Such consideration would have come on a separately filed motion, and we express no opinion as to whether such claims would be barred in the event such a motion is filed. Done with that footnote, back up. Nor, if we simply treat this motion as a new motion, does Avery demonstrate why these claims are not procedurally barred under Escalano-Naranjo, setting aside the question of why the claims were not alleged in the June 2017 motion. Avery has not explained why they were not alleged in the 2013 motion or on direct appeal. Another footnote. On appeal, Avery inexplicably argues that the state is stopped from raising ... procedural bar arguments, unquote, relating presumably to both, italicized, this October 2017 motion to reconsider and, italicized, his earlier June 2017 motion, based on the sole fact that the state represented in September 2017 that it would not oppose amendment of the June 2017 motion. Assuming without deciding that the doctrine of estoppel might apply to the post-conviction process under some circumstances, here the state's representation clearly had no bearing on a motion already filed and, as a matter of law, could not relieve Avery of his burden in any subsequent motion to demonstrate why newly raised claims were not procedurally barred. Back up before the footnote. We do note that buried in the motion are two claims based on evidence that appears on the face of the claims to be newly discovered. According to Avery, in October 2017, his sister, Barb Tadek, who lived in the Avery property and whose son, Bobby Dassey, Avery identifies as an alternative suspect to the crime, told him two pieces of information that would impeach her son's testimony about last seeing Halbach walk toward Avery's trailer on the day of her disappearance. In Avery's view, his sister, quote, admitted that she knew that Halbach had left the property, unquote, on the day in question. This evidence, however, is equivocal and does not clearly establish that Halbach in fact left the property on the day of her death, or that any witness was aware of or lied about this fact at trial. And another footnote that says, on appeal, I'm reading the other footnote. Second footnote. It says, the first piece of evidence is recorded statements in an October 2017 phone call between Avery and Barb Taddock and her husband, Scott Taddock. Avery identifies the full relevant portion of the transcript. It follows: Stephen Avery, Bobby's home. Barb Taddock, he wasn't always home. Stephen Avery, well, most of the time he was home. Barb Taddock, no. Scott Taddock, he doesn't know fucking shit. Stephen Avery, and he said he left. She left. Scott Taddock, that's right. Back up. Moreover, the evidence does not bolster any claim in the June 2017 motion so as to warrant reconsideration of that motion. And now we are on page 75 of 89. CN says, am I correct in thinking that they proved Teresa left the property from cell phone tower pings? Correct. At least her phone did. And so did Bobby. And their pings are the same place. Even viewed on its own merits, evidence does not entitle Avery to a hearing because he has not shown that it is material. At best, we have two unsworn statements by Barb Taddock that Dassey told her, italicized, something that is potentially inconsistent with his trial testimony. That is hearsay that would be inadmissible at a new trial, meaning that it cannot constitute newly discovered evidence as a matter of law. Avery chose to frame these claims in the context of a motion to reconsider. Oh, there's more of that phone call. I'll get to that in a second. Avery chose to frame these claims in the context of a motion to reconsider, but without applying that legal standard, or in the alternative, explaining why he had a sufficient reason for not bringing the claims in previous motions pursuant to Escalano Naranjo, as discussed in the section on the June 2017 motion. I'm going to go back and read. It's more of that footnote of their phone call. Barb Taddock, yeah, she left. Stephen Avery, yeah. Barb Taddock, yeah. Stephen Avery, well, he didn't testify for that. Barb Taddock, ugh. The second piece of evidence is an October 2017 posting on Barb Taddock's Facebook page. Avery identifies the full relevant portion of the posting as follows. Barb Taddock, well, I have your answer for all of you that was wondering. Just got off the phone with Bobby and I asked him if he told me that. He's seen her, presumably Halbach, pull in, but that was it because he left to go hunting then. He said that is the truth. A commenter, a Facebook friend, said, so he never seen her walk towards Stephen House? And Barb Taddock replies, no. All right, back to where I was. We are willing to give Avery the benefit of the doubt where possible, sure you do, as to why he did not raise certain claims in 2013 or on direct appeal. But we cannot ignore the law, and thus we cannot simply determine whether the merits of his motion to reconsider claims warrant an evidentiary hearing, where the only narrow question before us is whether the circuit court erroneously exercised its discretion in not considering, this is italicized, the June 2017 motion on the basis of purported new evidence contained within those claims. Next footnote says, although the merits of this case, of their claims, are not properly before us, we have reviewed them in our broader review of this appeal. We note that the evidentiary basis for some of these claims is lacking. For example, one claim is based on Avery's assertion that Ryan Hilgas, Halbach's ex-boyfriend, later possessed a day planner that was in her car on the day of her death. The evidence Avery submits, however, does not and cannot reasonably be construed to support this conclusion. Moreover, other claims do not appear on their face to entitle Avery to a hearing. For example, one claim, as far as we can tell, is based on a recreation of what Halbach's movements would have been had she driven away from Avery's property on the date of her death. From this experiment, which is unsupported by any explanation as to how Avery might prove the underlying hypothetical scenario that Halbach did in fact leave, Avery seeks to implicate Bobby Dassey and Scott Taddock, his brother-in-law, in Halbach's murder. Let me make sure there's not more of... Okay. So now back up before the footnote. We conclude that the Circuit Court did not erroneously exercise its discretion in denying this motion. The court noted that Avery provided no explanation for filing the June 2017 motion while, quote, considerable investigation was still being conducted by the defense, unquote. And now this is citing that, saying, knowing that not all the facts were ... ready for presentation to the court, and with no deadline for filing his motion set by the court or statute, the defendant proceeded to file the motion prematurely ... The motion was pending before this court for a few months before the court issued its ruling. During that period, the defendant did not ask the court to stay its ruling pending the conclusion of testing, request time to supplement the motion, or take any other action requesting that the court delay its final decision in this matter. This motion was submitted to this court, and the court led on the motion. This explanation is reasonable and sound and represents an appropriate exercise of discretion. So one court patting another court on the back. You were right. Good job. Motion number 4. Supplement July 2018 supplemental motion. Avery appealed from the Circuit Court's October 2017 and November 2017 orders denying his June 2017 motion and his motions to vacate and reconsider, respectively. In May 2018, Avery moved this court directly, quote, to supplement the record on appeal with a CD disclosed to defendant for the first time on April 17, 2018, unquote. Avery asserted that supplementation of the appellate record was appropriate because the contents of the CD related to claims already presented to the Circuit Court. We stated that this assertion, quote, misses the point, which is that we are not a fact-finding court and cannot consider items not presented to the Circuit Court, unquote. We determined, however, quote, based on the assertion that Avery recently received previously withheld discovery or other new information, we retain jurisdiction but remand this case to enable Avery to file an appropriate supplemental post-conviction motion in the Circuit Court, ... within 30 days of the date of this order. The Circuit Court shall hold proceedings on the supplemental post-conviction motion within 60 days after the motion is filed, unquote. In July 2018, Avery filed his motion to supplement the July 2018 motion, alleging a Brady violation. This footnote says, the state points out that a motion already decided, i.e. the June 2017 motion, cannot be supplemented, and that therefore the July 2018 motion is a successful motion. Regardless, this court has determined and ordered that the July 2018 motion, as well as the subsequent March 2019 motion, or motion number 5, shall be treated as a supplement to the June 2017 motion. Now back up. Recall that prior to trial, Avery unsuccessfully moved to introduce third-party liability evidence pursuant to State v. Denny. In his July 2018 motion, Avery alleges that the state withheld significant evidence both favorable to his Denny motion and relevant for impeachment purposes. A final investigative report to Detective Mike Velli saved on a CD, the Velli CD. Velli created the report through forensic examination of the hard drive of a computer used by Dassey, whom Avery identifies as a possible Denny suspect. The Veli CD contains thousands of images of violent pornography that Avery argues, quote, reveal a propensity for sexual violence, unquote, by Dassey. Avery elsewhere attempts to explain why, of several people who use the computer, only Dassey could have downloaded the images. The CD also contains a timeline that purportedly, quote, impeaches Dassey's trial testimony, unquote, and, quote, criteria, word searches, registry, recovered pornography, internet history, Windows registry, and all MSN messages, unquote. According to Avery, he did not receive the Veli CD until April 2018. The circuit court determined that there was no Brady violation because there was no evidence suppressed, and we agree. Footnote says, as this claim was to be treated as a supplemental motion pursuant to this court's order, Avery was not required to allege a sufficient reason under Escalano Naranjo for not raising the claim in his June 2017 motion. We assume without deciding that Avery had a sufficient reason for not raising this claim in his 2013 motion or on direct appeal based on the purported unavailability of the evidence. Back up. It is undisputed that the computer was examined and its content copied to 7 DVDs. It is undisputed that Avery's counsel received these 7 DVDs prior to trial. Finally, it is undisputed that, with limited and irrelevant exception, footnote says, Veli attests the only information on the CD titled Dassey Computer Final Report Investigative Copy that is not contained in the 7 DVDs would be the typical administrative and procedural files, folders, and techniques routinely used by a digital forensic examiner during a forensic examination of digital evidence. Back up. The Veli CD does not contain any additional information than what is on the 7 DVDs. Subsequently, the Veli CD is not suppressed evidence, but merely an investigative summary of evidence provided to Avery. So it's not suppressed, it just wasn't given to them. I don't know the difference. Avery appears to acknowledge these facts on appeal, but argues that he should have had access to information derived from Veli's, quote, unique word searches, unquote, pornographic images refined for relevancy, and the like. This is not the law. Brady on its terms applies to favorable and material suppressed evidence. That's italicized. And Avery has presented no authority extending this principle to the prosecution's withholding of secondary, this is italicized, secondary compilations or analysis of such. Brady only, this is quote, Brady only applies to facts that are not already known to the defendant. The government need not facilitate the compilation of exculpatory material with some industry defense counsel could marshal on their own, unquote. I missed a footnote. All right, so I'll read this footnote. Avery's computer expert attests that Avery did not receive critical information. Did I read that already? I think I read that. Okay. We are now on page 80 of 89. I'm in the home stretch. Was her skull ever recovered? There were something that looked like a skull that had kind of a curvature in it that they say means a bullet went through there. That's their evidence. Avery raises 2 related arguments concerning the disclosure of the DVDs themselves. He argues that the state deliberately misled him about the importance of the DVDs by stating in an email that they, quote, did not include much of evidentiary value, unquote. Even if the statement mischaracterized the evidence, So even if they lied, let's just change those, the lawyer speak or the judge speak. Even if they lied, however, an off the cuff description of disclosed evidence cannot form the basis for a Brady violation. Avery further argues that he was only provided the DVDs approximately 1 month before his Denny hearing, leaving him, quote, completely impaired, unquote, in his ability to introduce relevant evidence in that proceeding. But this argument properly concerns alleged ineffective assistance of trial counsel, because such conclusory statements do not adequately explain why trial counsel could not have analyzed the DVDs in time for the motion hearing, sought to postpone the hearing, or taken any number of the steps to effectively leverage this evidence. In the July 2018 motion, Avery does indeed argue that trial counsel was ineffective for failing to forensically examine the 7 DVDs prior to trial. He does so summarily, however, and in a manner that leaves us unable to meaningfully analyze this claim. Regarding potential use of this evidence in his Denny motion, Avery does not address the prejudice prong of the Strickland test, which, in our view, encompasses at least 2 key inquiries. To admit evidence at trial that Dassey could have killed Halbach, Avery would have had to provide some evidence at the pretrial Denny hearing directly, italicized, connecting Dassey to the crime. That Dassey possibly possessed violent pornographic images might have conceivably satisfied a separate requirement, motive, but is insufficient in and of itself to allow admission of third-party liability evidence. And a footnote. Although only tangentially, I don't know that word, big word, relevant to our decision, we note that Avery's counsel misrepresented some key facts underlying this claim in the motion to the circuit court and briefing to this court. Avery asserts that only Dassey could have downloaded the images, created folders containing photographs of Halbach, and, quote, searched for key terms relevant to the murder, unquote. He states that Dassey, quote, was the only individual at home, unquote, when this computer activity took place, but references for support only the affidavit of his computer expert, who does not and cannot opine on Dassey's schedule, and a sheriff's department interview with Dassey containing none of this information. Avery also characterizes the pornographic images as, quote, bearing a striking resemblance to Halbach and to the nature of the crime committed against her, unquote. As far as we can tell, there is no support for this conclusion in the evidence on record. That Avery misrepresented the facts is immaterial to deciding his Brady and ineffective claims. We point them out because of the high-profile nature of this case, the greater possibility that interested members of the public will read the briefing and motions, and the resulting need, where misrepresentations are particularly egregious, to note where Avery's arguments wholly stray from the facts. Back up from that footnote. Avery failed to meet the direct connection requirement in his original Denny motion and has not presented additional information on this point in motion number 4. Thus, even assuming trial counsel was deficient in not analyzing the DVDs, Avery cannot demonstrate a reasonable probability of a different outcome at the Denny hearing or a trial. The next footnote says, as discussed below, we are not addressing Avery's most recent filing to this italicized court, which seeks to directly connect Dassey to Halbach's murder. If Avery wishes to raise that claim, he will need to bring a new motion. That motion would need to survive both a Scalana Naranjo scrutiny and be found to have merit, in which case evidence presented might supply the missing direct connection. In that event, the Veli CD might become relevant to showing Dassey's motive and might bear on whether Dassey is or should have been a viable Denny suspect. We express no opinion on the merit of any such motion, and all such issues would be for the circuit court to decide in the first instance. And back up. Regarding the use of this evidence for impeachment purposes, even accepting that the CD contains, quote, a timeline that impeaches Dassey's trial testimony, unquote, we are skeptical of this point. Avery does not explain how impeaching Dassey about his use of the computer would have changed the outcome of the trial. At most, the jury would have disbelieved Dassey's testimony that on the day Halbach last visited the Avery property, he saw Halbach walk toward Avery's trailer. He did not see her leave the property. Halbach's RAV4 was in the driveway when he left to go hunting, and the RAV4 was gone when he returned several hours later. Avery identifies these as key pieces of testimony. Certainly, this testimony bolstered the state's theory that Halbach visited Avery on the day and did not leave the Avery property thereafter. But absent this testimony, the state still possessed significant forensic and other evidence implicating Avery in a crime committed on his property. Without any showing or argument as to why the impeachment of Dassey would have undermined the cumulative effect of the other evidence, we cannot conclude that the trial's outcome would have been different. We conclude that the circuit court did not err in denying the July 2018 motion without a hearing. And I again call bullshit on you don't know what a jury would think. Bullshit, bullshit, bullshit. Motion number 5, March 2019 supplemental motion. In January 2019, Avery again moved this court directly to stay the appeal and remand for the circuit court's consideration of specific claims relating to the state's 2011 release to Halbach's family of suspected human bone fragments. We determined that, quote, given the specific circumstances of this case, unquote, we would stay the appeal and remand pursuant to statute blah blah for action on this issue. We again ordered remand to the circuit court to permit Avery to pursue a supplemental post-conviction motion on specific claims, and we directed the court to conduct any necessary proceedings. The circuit court denied the motion without a hearing. The gist of motion number 5 is that the state released to Halbach's family suspected human bone fragments recovered from the Manitowoc County gravel pit, thereby violating 1. a circuit court order, 2. Wisconsin statute blah blah that requiring the state to preserve certain biological material evidence connected to a criminal conviction, and 3. Avery's constitutional rights. Chuck, chuck, chuck. As a motion may raise only jurisdictional, constitutional, and like claims, we consider only the third argument. Avery alleges that in 2011, the state improperly released to Halbach's family bone fragments from the gravel pit, which Avery wished to test to determine if they contained Halbach's DNA and might thereby indicate that Halbach was not killed on Avery's property. Avery argues that, quote, the state, by its actions in returning the bones, has implicitly admitted that the bones were not only human, but that they belonged to Ms. Halbach, unquote. Avery frames this as a violation of Arizona versus Youngblood, under which a defendant's due process rights are violated where the state either 1. fails to preserve apparently exculpatory evidence, or 2. acts in bad faith by failing to present potentially exculpatory evidence. Avery represents that he was not aware and could not reasonably have been aware of the release of the bones until after he filed his 4th motion. We will assume, therefore, that this claim is not procedurally barred under Escalano Naranjo. The state argues that the Youngblood analysis only properly applies to the destruction of pretrial evidence. We agree generally, but need not explore this point because Avery's claim fails on its terms. And the post-it footnote says, oh, it's all about the Youngblood and Greenwell cases, and then it says at the very end, because Avery has not alleged a Youngblood violation, we need not delve more fully into this point. All right, so back up. The premise of Avery's argument is that the state released to Halbach's family evidence that was either apparently or potentially exculpatory, bone fragments from the gravel pit that may have been Halbach's. This evidence, when first collected, was labeled as containing some human bone fragments. At trial, however, the undisputed testimony of the state's forensic anthropologist was that on further analysis, the bone fragments could not be definitively identified as human, much less as belonging to Halbach. On this record, therefore, this evidence is not apparently exculpatory. It does not indicate that another person killed Halbach. Nor can Avery establish that this evidence is potentially exculpatory, because even assuming that these bone fragments are Halbach's, Avery does not explain the significance of this fact. Yeah, he does. The apparent thrust of Avery's claim is that if Halbach's bones were found in the gravel pit, then she was killed by someone else. But as Avery never explains why he himself would have been unable to dispose of Halbach's remains in the gravel pit, well, because Sweaty Sweat Sweat says he never left, this line of reasoning is wholly speculative. Moreover, Avery cannot show bad faith, meaning, quote, 1, the officers were aware of the potentially exculpatory value or usefulness of the evidence they failed to preserve, and 2, the officers acted with official animus or made a conscious effort to suppress exculpatory evidence. The record reflects only that the state released bone fragments of indeterminate origin after Avery's direct appeal was fully litigated, when there appeared no direct or immediate need to preserve this evidence. And contrary to Avery's argument, the very fact that the state released the bones does not mean that these are Halbach's or that the state acted in bad faith to destroy the evidence. The Halbach family requested these bone fragments for purposes of its own, likely for closure. But that does not vest these fragments with evidentiary significance. And the footnote says, Avery suggests that the state also acted in bad faith in 2018 during the post-conviction process by actively misleading him about whether it still possessed the bone fragments, the point at which to measure the state's bad faith. However, is when it allegedly destroyed the evidence here in 2011 when it released the bone fragments to Halbach's family. Before I move in there to the next section, and we're going on 4 hours of reading. Sun is fully up now. It is 8:18 a.m. now here in Chicagoland. If those are not Teresa's bones, why did the Halbach family want them? Why did the Halbach family then cremate them and put them with the rest of her cremains? If they are not Halbach's, why would the state give them to the Halbach family just because they asked for it? So could the Halbachs ask for Stephen's groin swab and get that too? Because they asked for it and they want closure? Why are you covering evidence? Why are you hiding? Why hasn't Kathleen Zellner have the actual RAV4? Why can't she do tests on that? Why are you hiding it? If you want justice for what happened to Teresa Halbach, why do you hide those bones? Why are you hiding the car? Why are you denying bringing this into court and letting people hear and see this evidence? We are now on page 86 of 89. Motion number 6. And what I'm currently reading is, at the very beginning of this 4 hours ago, when we started, it was the state's response to Kathleen's latest filing in wanting Judge Flowers to deny a hearing. They cited that all of this should be denied because the court previously denied it. And then they've included the previous court's ruling. And that's what we are reading currently. It's a refresher, too. Whatever. Motion number 6, April 2021, motion to stay in remand. On November 9, 2020, we notified the parties that this case had been submitted to the court for decision on briefs. On April 12, 2021, Avery filed another motion with this court to stay his appeal and remand for evaluation of a new claim. This claim concerns an alleged Brady violation, the factual basis for which Avery purported obtained on April 11, 2021. Specifically, the claim is based on the affidavit of Thomas Sawinski, a Manitowoc motor route driver who attests that days after Halbach's death, while on his paper route in the early morning hours, he spotted a shirtless Dassey and an unidentified older man pushing Halbach's vehicle down Avery Road towards the junkyard. Sawinski further attests that, after he delivered the paper, Dassey attempted to block his exit, causing him to swerve and drive into a shallow ditch. Sawinski claimed to have called the Manitowoc Sheriff's Office later that day to report what he had seen, but was told they already know who did it. He also claims to have attempted to contact Avery's trial attorneys after season 1 of Making a Murderer, but never heard back from them. When Avery filed this motion, we had already twice stayed his appeal, each time because he asserted that the new claims related to those previously litigated and that it would be most expeditious to resolve them as part of the instant appeal. By the time Avery filed this new motion, however, we had already evaluated the legal and factual basis for claims already raised. We therefore were and are in the position to conclude that this newly raised Brady claim bears little or no relation to those claims already before us. That is instead a distinct issue that is the word that is there twice, that the circuit court should resolve on a standalone basis through a new Wisconsin motion. Moreover, Avery's latest motion arrived while a decision on his appeal was forthcoming. It would be inefficient use of court resources to now and once again delay this appeal's resolution. We appreciate that Avery likely wishes us to consider this new Brady claim in the context of claims previously raised, but we must weigh that implicit consideration against those discussed above. Simply put, Avery's appeal cannot continue indefinitely. Accordingly, this decision operates as an order denying Avery's April 12, 2021 motion to stay in remand. If Avery wishes to raise this claim, he must file a new motion with the circuit court. Pursuant to Escalona Naranjo, Avery will need to demonstrate why he could not have previously raised this claim, including in his June 2017 motion, before the merits can be reached. Conclusion. Avery raises a variety of alternative theories about who killed Halbach and how, but as the state correctly notes, a motion is not a vehicle to retry a case to a jury. A criminal defendant is constitutionally entitled as of right to a jury trial, and if correct, I'm just really messing up my words now. If convicted, a direct appeal. If he or she later seeks to collaterally attack the conviction on constitutional or jurisdictional grounds, a motion is appropriate. But key to any motion are sufficient non-conclusory showings, both as to why the issue was not raised in an earlier post-conviction proceeding and why the claim has facial merit. These requirements are not optional and cannot be met through broad conclusions or by misstating evidence. We express no opinion about who committed this crime. The jury has decided this question, and our review is confined to whether the claims before us entitle Avery to an evidentiary hearing. we conclude that the Circuit Court did not erroneously exercise its discretion in denying hearings on motions 1, 4, and 5, in not vacating its order on motion number 1, and is not reconsidering its ruling on motion number 1. As for motion number 6 and the portion of motion number 3, the motion to reconsider, raising new claims, we leave open the possibility that Avery may raise these new claims in a new motion. We remind Avery, however, that he will need to overcome the Escalano-Naranjo procedural bar on these claims, which includes providing a sufficient reason for not raising them in his June 2017 motion. Moreover, Avery will need to satisfy the previously discussed specificity requirements before such claims may proceed to a hearing. By the court, orders affirmed. This opinion will not be published. And that is it. The end of it. So, where we're at now, the state has asked the court to deny. Now we wait for Judge Flowers to rule. I do not know if there is a time frame. I never remember if a judge has 30 days, 60 days, or it's indefinite. But now we wait for Judge Flowers to rule. And it is always assumed she will say no, as she has multiple times before. And then Kathleen Zellner will have to take it to the next court. That's where we're at. I have been reading for 4 hours and 4 minutes. I am not going to keep discussing anything. I am so done, and my dogs are so done down there barking, wanting to go outside. Let me try and copy this. Here again is what I just read. There's a separate post here on Stephen Avery Project where that link has been posted to that if you want to go through and read this all for yourself. I do not know the next time I'll be going live to discuss this case. I know I will be live this week on Justice with Jax because another case that I am on, the Marnie Yang case, we go to court on the 30th. So we'll be live over on Justice with Jax to talk about what happened in the Marnie Yang case. If Judge Flowers responds quickly, whenever she responds, we'll go live in reading that. Don't know if it will be here on Facebook or if we do it on the Justice with Jax YouTube page. I know I'm not going to go through and reread all of that anywhere else since this took me 4 hours to do. But it's still more of a waiting game. And yes, today I am celebrating Thanksgiving with my family in, what is it, 9:30, 10:30, 11:30, 12:30, 1:30, 6.5 hours. And I haven't slept yet. Yay. So I'm out. I hope you all have a great weekend. I guess, should I do a plug? My book, Wrongfully Abused, is available in hardcover and paperback and ebook on Amazon. Wrongfully Abused by Jax West. It's holiday season. Pick one up for yourself and gifts for all your friends and family. All right. I'm going to feed my dogs, let my dogs out. I think I'm going to run to McDonald's and get breakfast, and then I'll try and take a nap. Thank you, everybody. Investigation continues.